The sitting is open. The Court meets today and will meet tomorrow under Article 74, Paragraph 3 of the Rules of Court to hear the oral observations of the parties on the request for the indication of provisional measures submitted by the Republic of South Africa in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel.
Mr. Talbecker.
The Court does not include upon the bench a judge of the nationality of either party. Accordingly, both parties avail themselves of the right under Article 31, Paragraph 3 of the statute to choose a judge ad hoc.
Distinguished
South
members of
Africa
the
has
Court,
chosen Judge Dikkan
it is an honor to appear before you
and Israel,
again
Judge
on behalf
Aharon
of the
Barak.
State of Israel.
Article 20 of the statute provides that
The State of
every
Israel
member of
is
the Court
singularly
shall,
aware
before taking up
of
his
why the
duties,
Genocide
make a
Convention,
solemn declaration
which has
in
been
open
invoked
court
in these
that he will
proceedings,
exercise his
was
powers
adopted.
impartially and conscientiously.
Seared in our collective memory
Pursuant to Article 31,
is the
Paragraph
systematic
6 of the
murder of
statute,
6 million Jews
that same provision
as
applies
part of
to
a
judges ad
premeditated
hoc.
and heinous program
Before inviting
for their total
Judge
annihilation.
Moseneke and Judge Barak to make their
Given the
solemn
Jewish people's
declarations, I
history
shall first,
and
in
its
accordance with
foundational
custom,
texts,
say a few words
it is not
about their
surprising
careers and
that
qualifications.
Israel was among the first
Judge
states to
Dikkan
ratify
Ernest
the Genocide
Moseneke of South
Convention
African
without
nationality
reservation,
has had a distinguished
and to
career as a
incorporate
judge,
its
law
provisions in its
practitioner, and
domestic
academic.
legislation.
After obtaining degrees in
For some,
English, political science, and
promise of
law
never again
from the
for all
University of
peoples
South Africa,
is a
he
slogan.
practiced as an attorney
For
and an
Israel,
advocate with the
it is the
Pretoria
highest
Bar.
moral obligation.
In 2001,
Raphael Lemkin,
he was appointed a
a Polish
judge
Jew
on the High Court
who
in
witnessed the
Pretoria,
unspeakable
and a year
horrors of the
later,
Holocaust,
he became a judge on
is
the
credited with
Constitutional Court
coining
of
the
South
term
Africa,
genocide.
where he was Deputy Chief
He helped
Justice
the
for
world
more than a decade
recognize
and
that
acting
the
Chief
existing
Justice
legal lexicon
in 2013
was simply
and
inadequate
2014.
to capture the
Judge
devastating
Moseneke
evil
is also an
that the
honorary
Nazi
professor
Holocaust
in the
unleashed.
Department of Jurisprudence at the University
The
of
applicant
Pretoria and
has
has
now
served as
sought
a
to
chancellor
invoke
of the
this
Pretoria
term
Technikon
in the
and the
context
University
of
of
Israel's conduct
Witwatersrand in
in a
Johannesburg.
war it did not
Judge
start
Moseneke has received
and did
numerous
not want.
honorary doctorates and awards.
A war in which
I
Israel
shall
is
now say a
defending
few
itself
words about
against
the career
Hamas,
and qualifications
Palestinian
of Judge
Islamic
Barak.
Jihad, and other
Judge
terrorist
Aharon Barak
organizations
of Israeli nationality
whose brutality
has had
knows
an eminent
no
career
bounds.
as a judge and law professor. He holds a PhD
civilian
in law
suffering in
from
this
the
war,
Hebrew University of Jerusalem
like in all
and served
wars,
as the dean of the
is
Faculty
tragic.
of Law of that university between
It is heartbreaking.
1974 and
The harsh realities
1975.
of the current
He was
hostilities
appointed to the
are
Israeli
made
Supreme
especially
Court
agonizing for
in
civilians,
1978 and served
given
as its
Hamas's
president
reprehensible
from
strategy
1995 to
of seeking to
2006.
maximize civilian harm
Prior to joining the Supreme
to both
Court, Judge
Israelis
Barak
and
served
Palestinians,
as the Attorney General of the State
even
of
as Israel seeks to
between
minimize it.
1975 and
But as this court
1978.
has already made
He has
clear,
taught law in a number
the
of law
Genocide
schools,
Convention
including
was not
Yale
designed
University,
to address
the Hebrew University
the brutal
of Jerusalem,
impact of
and the
intensive
Reichman
hostilities
University in
on the
Herzliya,
civilian
Israel.
population,
Judge Barak has also
even
written
when the use of
extensively
force
in law and has
raises
received numerous
quote,
honorary
very
degrees
serious
and
issues
awards.
of international law
In accordance with the order
and
of
involves
precedence
enormous
fixed by
suffering
Article 7, Paragraph 3
and
of the
continuing
Rules
loss
of
of
Court,
life.
I shall
End
first
quote.
invite Judge Moseneke to make the solemn
The
declaration
convention was set apart
prescribed by the statute,
to address
and I
a
request
malevolent
all those
crime
present to
of the
rise.
most exceptional severity. We live at a time when words are cheap.
Judge Moseneke, you have the floor.
In an age of social media and identity politics, the temptation to reach for the most outrageous term,
solemnly declare
to vilify
that
and
I will
demonize,
perform my
has become
duties
for many irresistible.
and exercise my powers
But if there is a
as a
place where
judge
words should
honorably,
still matter,
faithfully,
where truth should still matter,
impartially,
it is surely
and
the court of law.
conscientiously.
I
The
thank Judge
applicant has
Moseneke,
regrettably put
and I
before
now
the court
invite Judge Barak to make the
a
solemn
profoundly distorted factual and legal
prescribed by the
picture.
statute. Judge Barak, you have the floor.
The entirety of
I
its
solemnly
case
declare
hinges
that I
on
will
a
perform my
deliberately
duties
curated,
and exercise my powers as
decontextualized,
judge
and manipulative
honorably,
description
faithfully,
of the reality
impartially,
of current
and
hostilities.
consciously.
I thank you, Judge Barak.
South Africa
Please be
purports to
seated.
come to this court in the lofty position of a guardian of the interest of
I
humanity.
take note of the solemn declarations
But
made
in
by Judge
delegitimizing Israel's
Moseneke and Judge
75-year
Barak,
existence
and I declare them
in its
duly
opening
installed as
presentation
judges ad
yesterday,
hoc in the
that
case
broad
concerning
commitment to
application of the
humanity
Convention
rang
on the
hollow.
Prevention and Punishment of the Crime of Genocide in
And
the
in its
Gaza Strip,
sweeping
South Africa
counterfactual
versus
description
Israel.
of the
I shall now
Israeli-Palestinian
recall the
conflict.
principal steps of
It
the
seemed
procedure
to
in the
erase
present
both
case.
Jewish history
On 29 December
and any
2023,
Palestinian agency
the
or
government of South
responsibility.
Africa filed in the registry of the court
Indeed,
an application instituting proceedings
delegitimization
against
of
the State of
Israel,
Israel, alleging
since its
violations
very
by the latter of
establishment
its
in
obligations
1948
under the
in the
1948
applicant's
Convention
submissions
on the Prevention and
sounded
Punishment of
barely
the Crime of
distinguishable
Genocide. I shall
from
refer to this
Hamas's
convention
own
as the Genocide
rejectionist
Convention.
rhetoric.
To found the
It is
jurisdiction of the court,
unsurprising,
South
therefore,
Africa invokes Article
in the applicant's
36,
telling,
paragraph 1 of the
both
Statute
Hamas's
of Court and Article
responsibility
9
for the
of the
situation
Genocide
in Gaza
Convention.
and the
South
very
Africa
humanity
states
of its
that
Israeli
applications
victims
concerns
are
acts
removed
threatened,
from view.
adopted, condoned,
The
taken, and
attempt
being
to
taken
weaponize
by
the
the
term
government and
genocide against
military of Israel
in the
against the
present
Palestinian
context
people, a
does
distinct
more than tell
national,
the court
racial, and
a
ethnic
grossly
group,
distorted
in the wake
story.
of the attacks in Israel on
And it
7
does more
October
than empty the word
2023.
of its unique
South Africa
force
contends
and
that
special
the
meaning.
acts and omissions by Israel of
It
which it
subverts
complains
the object
are
and
genocidal
purpose
in
of the
character
convention
because,
itself,
I quote,
with
they are intended
ramifications
to bring about
for all
the
states
destruction of a
seeking to
substantial
defend
part of the
themselves
Palestinian
against those who
national,
demonstrate
racial, and
total
ethnic
disdain
group, that
for
being the
life
part of the
and
Palestinian
for the law.
group in the Gaza Strip. End
Madam
of quote.
President, members
South
of the
Africa
court,
asserts that the relevant
on
acts
Saturday,
are attributable
October
to
7th,
Israel,
a Jewish
which has
religious
failed to
holiday,
prevent genocide and is committing
thousands of
genocide,
Hamas and
and
other
which has
militants
also violated
breached
and
Israeli
continues to
sovereign
violate
territory
other fundamental
sea,
obligations
land,
under the
and air,
Genocide Convention.
invading
The
over
application
20 Israeli
contains a
communities,
request for the
bases,
indication of provisional
and the
measures
site of a music
pursuant to
festival.
Article 41 of the Statute
What
of
proceeded
Court and Articles
under the
73,
cover of thousands of
74,
rockets
and
fired
75 of the Rules
indiscriminately
of
into
Court.
Israel
According to South Africa,
was the wholesale
I quote,
massacre,
provisional measures are
mutilation,
necessary in this case
rape, and
to protect
abduction
against further
of as many
severe and
citizens as
irreparable
the
harm
terrorists could
to the
find
rights of the Palestinian
before
people
Israel's
under the
forces
Genocide
repelled them.
Convention, which continued to be
openly
violated with
displaying
impunity.
elation.
South Africa
They
requests
tortured
that the court
children
indicate
in front of
provisional
parents
measures to
and
protect and
parents
preserve those
in front of
rights,
children,
as well as its own rights under the
burned
Convention,
people, including
and to
infants
prevent
alive,
any aggravation or
and
extension of the
systematically
dispute,
raped
pending
and
the
mutilated
determination of the
scores
merits of
of
the
women,
issues
men,
raised
and
by
children.
the application. End of quote.
All told,
The
some
registrar will
1,200
now
people
read
were
out
butchered
the
that day,
passage from the request
more than
specifying the provisional
5,500
measures,
maimed,
which the government of South
and
Africa
some
is asking the court
240
to
hostages
indicate.
abducted,
You have the floor, Mr. Registrar.
including infants, entire families,
Thank you, Madam
persons with
President.
disabilities,
I quote,
and Holocaust
1.
survivors.
The State of
Some
Israel
of whom
shall
have since been
immediately
executed.
suspend its military
Many of whom
operations
have
in
been
and
tortured,
against Gaza.
sexually
2.
abused,
The
and
State of
starved
Israel
in
shall
captivity.
ensure that any military or
Representatives
irregular
of the
armed
hostages'
units
families
which
are in
may
this
be
courtroom
directed,
today,
supported,
and
or
we acknowledge
influenced
their
by it,
presence
as
and
well
their
as
boundless
any
suffering.
organizations and persons which may
We
be
know of the
subject to its
brutality of
control,
October 7th,
direction, or influence,
not only from the
take no
harrowing
steps in
testimonies of the
furtherance of the
survivors,
military
the
operation referred
unmistakable
to
proof
point 1
of
above.
carnage and sadism left
3.
behind,
The Republic of South Africa and the State
forensic
of
evidence
Israel
taken
shall
at the scene.
each, in accordance with their
We know it
obligations under the
because the assailants
Convention on the
proudly
Prevention
filmed
and Punishment of the
broadcast
Crime of
their
Genocide in relation to the Palestinian
The
people,
events of that
take
day
all reasonable
are all but
measures
ignored
within
in the
their
applicant's
power to
submissions.
prevent genocide.
But we are
4.
compelled
The
to
State
share
of
with the
Israel
court
shall,
some
in
fraction of
accordance
its
with
horror.
its obligations under the
largest
Convention on the
calculated mass
Prevention
murder
and
of Jews
Punishment of the
in a
Crime of
single day
Genocide
since the Holocaust.
in relation to the Palestinian
We
people
do so
as a group
not
protected
because
by
these acts,
the Convention on the
however
Prevention
sadistic
and
and
Punishment of the
systematic,
Crime of Genocide,
release Israel of its
desist from the
obligations
commission
to uphold
of
the
any
law
and all
as it
acts
defends
within the
its
scope of
citizens and
Article 2 of
territory.
the Convention, in
That is
particular
unquestionable.
A. Killing members of the
We
group.
do so
B.
because it
Causing
is
serious
impossible to
bodily or
understand
mental harm to
the
the
armed
members of the
conflict in
group.
Gaza
C.
without
Deliberately
appreciating the
inflicting
nature of
on
the
the
threat
group
that Israel is
conditions of
facing
life
and
calculated
the brutality
about
and
its
lawlessness
physical
of the
destruction
armed force
in all or
confronting
in
it.
part. And D.
In the volume of
Imposing
materials
measures intended
submitted to
to
members of
prevent
the
births
court,
within the group.
access has been provided
5.
to a
The
portion
State of
the
Israel
raw
shall,
footage
pursuant to
separate
point
screenings.
4c above, in
But I am
relation to
obliged to put before the court
Palestinians,
today
desist from and
some
take all
small
measures
fragment
within its
of the
power,
scenes of
including the
unfathomable
rescinding
cruelty
of relevant
that took
orders,
place
of
in hundreds of
restrictions
locations
and or of
on that horrible
prohibitions to
day.
prevent A. the expulsion and forced displacement from their
and
homes.
his wife Tamar,
B. The deprivation of
an activist for women's
B1,
rights,
access to
lived in
adequate
kibbutz
food and
Nir Oz.
water. B2,
When
access
the
to
rocket fire started,
humanitarian
they hid in a safe
assistance,
room with their 4-year-old
including
son,
access
Omer,
to adequate
and their
fuel,
6-year-old
shelter,
twins,
clothes,
Abel and Shachar.
hygiene, and sanitation. B3,
During their
medical
rampage,
supplies
Hamas
and
militants set
assistance.
fire to
And
their house.
C, the destruction of
Johnny texted
Palestinian
his
life
sister
in
Renee.
Gaza. 6.
They're here.
The State of Israel shall,
They're burning
in
us.
relations to
We're
Palestinians,
suffocating.
ensure that its military, as
whole
well as
family
any
was burned
irregular
alive
armed units or individuals which may be
making
directed,
DNA
supported,
identification
or otherwise
especially difficult.
influenced by it, and any organizations
of the
and
Nova
persons
Music
which may
Festival
be subject to
massacre
its control,
testified
direction,
to
or
police to
influence
witnessing a Hamas
do not
militant
commit any act
brutally raping a
described
young
in
woman.
4 and
As
5
another
above,
militant cut off her
or
breast
engage in
and toyed
direct
with
and
it.
public
second militant
incitement
then
to
raped her
commit
again,
genocide, conspiracy
shooting her
to
in the head
commit
while
genocide,
still inside
attempt
her.
to commit genocide, or complicity in genocide.
In one video
And
recorded by a
insofar as
home
they
surveillance
do engage therein,
Hamas
that
militant
steps
throws
are
a grenade
taken
into a
towards their
safe room,
punishment
where a
pursuant to
father and his
Articles
2
1,
sons
2,
have
3,
rushed
and
to
4
hide.
of the Convention on the
father is
Prevention
killed.
and Punishment
The 2
of the
sons
Crime
are
of
injured and
Genocide.
bleeding.
7.
As a
The
militant
State of
pulls them into
Israel
the
shall
living room.
take effective measures to
One
prevent the
child can be
destruction
heard
and ensure the
screaming to his
preservation of evidence
Why
related
am I
to
alive?
allegations of acts within the scope
I
of
can't see
Article 2 of the Convention
They're
on
going
the
to kill us.
Prevention and Punishment of the Crime of
The
Genocide.
militant
To
casually
that
opens
end,
the fridge,
the State of Israel
takes out a bottle,
shall
and
not
drinks.
act to deny or otherwise to restrict
And then there
access
is this
by
recording
fact-finding
from Kibbutz
missions,
Mefalsim.
international mandates, and other bodies to Gaza to assist in ensuring the preservation and retention of said evidence. 8. The State of Israel shall submit a report to the court on all measures taken to give effect to this order within 1 week, as from the date of this order, and thereafter at such regular intervals as the court shall order, until a final
stated,
decision on the case is
None of
rendered
these
by the
atrocities
court.
absolve Israel of
9.
its obligations
The
under
State
the
of
law.
Israel shall refrain
But
from
they do
any
enable the
action
court
and
to
shall
appreciate
ensure that no
3
action
core
is taken
aspects of the
which
present
might
proceedings,
aggravate
which
or
the applicant
extend
has
the
obscured
dispute
from
before
view.
the court or make it more
First,
difficult to resolve.
That if there
End of
have been
quote.
acts that may be
I think
characterized
we're ready
as
to start.
genocidal,
Immediately after the
then they
application
have been
containing the request
perpetrated
for the indication of
against
provisional
Israel.
measures was filed,
If there
the
is a
Deputy
concern
Registrar
about the
transmitted
obligations
an
of
original
states
copy thereof
under
to
the
the
Genocide
Government of Israel.
Convention,
He also
then
notified
it
the
is in
Secretary
relation to
General
their
of the United Nations.
responsibilities to act
According to
against
Article
Hamas's
74,
proudly
paragraph 1 of the
declared
Rules of Court,
agenda of
a
annihilation,
request for the indication of
which is
provisional
not a
measures
secret
shall have
and is not in
priority
doubt.
over all other cases.
The
Paragraph 2 of the
annihilationist
same article
language of
states
Hamas's
that the
charter
court shall proceed to a
is
decision
repeated
on the
regularly
request
by
as
its
a matter of
leaders,
urgency.
with the goal,
This imperative
in the
must,
words
however,
of one
be
member of
balanced
Hamas's
with the
political
need to fix a
bureau,
date of oral
of the
proceedings
cleansing
in
of
such a way
Palestine
as
of
to
the
afford the
filth
parties
of the Jews.
an opportunity to be represented at the hearings.
It is expressed no less
Consequently,
chillingly
the parties were informed
in the words of
that the
senior
date for the
Hamas
opening
member
of the oral
Razi
proceedings,
Hamad
during
to
which they
Lebanese
could present
television
their observations
on
on the
October
request for the
24th,
indication of provisional
2023,
measures, had been fixed
who refers to
for
the
Thursday,
October 7th
11
attacks,
January 2024
what Hamas
at
calls
10 a.m.
the Al-Aqsa
I
flood.
would now like to welcome
as follows.
the delegations of South Africa and Israel, and I note the presence before the court of the agents and counsel of both parties. This morning the court will hear the single round of oral argument of South Africa, which has submitted the request for the indication of provisional measures. It will hear Israel tomorrow morning at 10 a.m. For purposes of this single round of oral argument, each
In the
party will have
continuation
available
of this
to
interview,
it a 3-hour
Hamas is
sitting.
asked,
In this first sitting, South Africa
Does
may,
that
if
mean the
required, avail
annihilation of
itself
Israel?
of a short extension
Yes,
beyond
of
1
course,
p.m.
he
today,
says.
in view of the time
The
taken up by
existence
these
of Israel
introductory
is
remarks.
illogical.
Before I give the
And
floor
then
to
he
the agents of
says,
South Africa,
nobody should
I wish to
blame
draw
us
the party's
for the things
attention
we do.
to practice direction
On October
11,
7th,
which states as follows,
October
quote,
10th,
in oral
October 1
proceedings on the
millionth,
request for the indication of
everything
provisional
we do
measures,
is justified.
parties should limit themselves
quote.
to what is relevant to the
Given
criteria
that on
for the
October
indication
7th,
of provisional measures
before any
as
military
stipulated in the
response by
statute,
Israel,
rules and
South Africa
jurisprudence of the
issued an
court.
official
They
statement
should not enter into the
blaming
merits of the
Israel
case beyond
for,
what is
quote,
strictly
the
necessary
recent
for that
conflagration,
purpose. End of quote.
essentially
I now give
blaming
the floor
Israel for the
to
murder of
agent
its
South
own
Africa,
citizens.
His Excellency,
One
Mr.
wonders whether
Dusumuzi
the applicant
Madonsela. You have the
agrees.
floor, Excellency.
Second, it is in response to the slaughter of October 7th, which Hamas openly vows to repeat.
Madam President,
and to the ongoing
distinguished
attacks
members of
against
the
it from
court,
Gaza,
it is an
that Israel
honor and a
has the
privilege for me
inherent right
to appear
to
before
take
you
all
today
legitimate measures to
on behalf
defend
of
its
the
citizens
Republic of South Africa.
and secure the release of
I wish
the
to
hostages.
express my gratitude to the court
This right
for
is
convening
also
this
not in
hearing
doubt.
on the earliest possible
It has
date
been acknowledged
to
by
entertain
states
South Africa's
across the
request
world.
for the indication of provisional measures in this
Astonishingly,
matter.
the court has been
In our
requested
application,
to indicate
South
a
Africa has
provisional measure
recognized the ongoing
calling on
Nakba
Israel to
of the
suspend
Palestinian people
its military operations.
through Israel's colonization since
But this amounts to an
1948,
attempt to
which
deny
has
Israel its
systematically and
ability
forcibly dispossessed,
to meet its obligations
displaced,
to the
and
defense of its
fragmented the
citizens,
Palestinian people,
to the hostages,
deliberately denying
and to
them
over
the internationally
110,000
recognized
internally displaced
inalienable right
Israelis
to self-determination
unable to safely
and their
return to their
internationally
homes.
recognized right of return as
The
refugees
applicant
to
in
their
its submissions
towns
to
and
the court
villages in
makes
what is
almost
now
no
the state
mention
of Israel.
of the ongoing
We are also
humanitarian
particularly
suffering
mindful of
Israel's
Israel's
citizens at the
institutionalized
hands of
regime
Hamas,
of discriminatory
and
laws,
treats the hostages
policies and
still
practices
held in
designed and
captivity
maintained
as
to
barely
establish
an
domination,
afterthought.
subjecting the Palestinian people
But is
to
there a reason
apartheid on
these
both sides
people
of the Green Line.
On your screen are
Decades-long
unworthy of
impunity
protection.
for widespread and systematic human rights violations has emboldened Israel in its recurrence and intensification of international crimes in Palestine. At the outset, South Africa acknowledges that the genocidal acts and omissions by the State of Israel inevitably form part of a continuum of illegal acts perpetrated against the Palestinian people since 1948. The application places Israel's genocidal acts and omissions within the broader context of Israel's 75-year apartheid, 56-year occupation,
is not a party to
and
these
16-year siege imposed
The
on the
applicant,
Gaza
by its
Strip,
request,
a siege
seeks
which
to thwart Israel's inherent right
itself
to defend
has
itself,
been described by the
to let
director
Hamas
of
not just get away with its
UNRWA
murder,
affairs
literally,
in Gaza
but render Israel
as a
defenseless
silent
as Hamas
killer
continues to
of
commit
people.
it. Yesterday,
As the
counsel for the
Committee on
applicant
the
made the
Elimination of
astonishing
Racial
claim
Discrimination
that Israel was
warned
denied this right,
on
and
December
as a matter of
21st,
fact should not be able to protect
hate
itself
speech and
from
dehumanizing
Hamas's
discourse
attacks.
targeted at
But
Palestinians
allow me to draw attention to these
is
words
raising severe
written by
concerns
Professor
regarding
Vaughan
Israel
Lowe.
and other states'
Quote,
parties'
the source of the
obligation to
attack,
prevent crimes
whether a
against
state
humanity
or non-state
and
actor,
genocide
is
in the Gaza
irrelevant
Strip.
to the existence of the
This
right to
warning has
defense.
been followed by a
Force
succession
may be
of
used to
warnings,
avert a threat
including
because
by
no one
37 United
and no
Nations
state is
special
obliged by law
rapporteurs
passively
of the
to
failure of
suffer
the
the
international
delivery
system
of an attack.
to mobilize to prevent
Israel
genocide
agrees with
in
these
Gaza.
words, as I suspect would any
Today,
sovereign state.
we are joined in court
If the
by
claim of the
representatives
applicant
of
now
the Palestinian state,
is that in the armed
the
conflict
Palestinians
between Israel
who
and
work in the
Hamas,
fields of
Israel must be
human
denied
rights,
the ability
including
to defend its
residents
citizens,
of Gaza who were
then the
in Gaza
absurd
just a few
upshot
days ago.
of South Africa's argument
They
is
are
this.
some of the lucky ones who
Under
managed
the
to get out
guise of the
Gaza.
allegation against Israel of
Their
genocide,
future and the
this
future
court
of their
is
fellow
asked to call for an
Palestinians
end to
who are
operations
still in Gaza
against the ongoing
depend
attacks
on
of an
the decision this
organization
court will
that
make on
pursues
this
an
matter.
actual genocidal
With the
agenda,
leave of the court,
an organization
I now
that has
call upon
violated
His
every past
Excellency,
ceasefire
Mr. Ronald
and used it to
Lamola, Minister
rearm
of
and
Justice
plan
of the
new
Republic of
atrocities.
South Africa,
An
to make South
organization that
Africa's
declares its
substantive
unequivocal
opening
resolve
remarks.
to advance its genocidal plans.
I thank the agent
That is
of
an
South Africa for
unconscionable
his
request.
statement, and I now invite the
it
Minister
is
of
respectfully
Justice and
submitted
Correctional Services
that it
for the
cannot
Republic of
stand.
South Africa, His Excellency
Third,
Mr. Ronald Lamola.
The court
to
is
take the floor.
informed
You
of
have
the
floor.
events of October 7th
Thank you.
because if
Madam
there are any
President,
provisional measures that should
and
appropriately
distinguished
be
members of
indicated
the
here,
court,
they are
It
indeed
is an
with
honor for me
respect to South
to stand
Africa.
here in front of
It
you
is a
on
matter of
behalf
public record
of the Republic of
that
South
Africa
Africa
enjoys
on this
close
exceptional
relations with
case.
Hamas, despite
In
its
extending
formal
our hands
recognition
across the
as a
miles
terrorist
to the
organization
people of
by
Palestine,
numerous states
we
across
do
the
so
world.
in full knowledge that
These
we are
relations
part
have
of a
continued
humanity
unabated
that is at
even
war.
after the October
These were the
7th
words
atrocities.
of our founding president,
South Africa
Nelson Mandela.
has long hosted and
This is the
celebrated its
spirit in which
ties
South Africa
with Hamas figures,
acceded to the convention
including a senior Hamas delegation
on the
that
prevention and
incredibly
punishment of crime
visited the
of
country
genocide
for a
in
quote,
1998.
solidarity gathering
This
just weeks
is the spirit
after
in
the
which we
massacre.
approach this court as
In
a contracting
justifying
party
instituting
to the
proceedings
convention.
South
This is
Africa
a
makes
commitment
much
to
of its
owe
obligations
to the people of
under the
Palestine
Genocide
and
Convention.
Israelis alike.
It seems fitting then
As
that it
previously
be
mentioned,
instructed to
the
comply with those
violence
obligations
and the
itself,
destruction in Palestine and Israel
to end its own
did not
language of
begin on the 7th of
delegitimization
October
of Israel's
2023.
existence,
The Palestinians
its
have
support for
experienced
Hamas,
systematic oppression
and use its
violence
influence with this
for the
organization
last 76 years.
so that Hamas
On
permanently
6 October
ends
2023,
its campaign of
and
genocidal
every
terror
day since October the
and
7th,
releases the hostages.
2023. In the
Madam
Gaza
President,
Strip,
members
at
of the
least
court,
since 2004, Israel continues to
hostilities
exercise
between
control
Israel and Hamas
over the
have
airspace,
exacted a terrible
territorial
toll
waters,
on
land
both
crossing,
Israelis and
water,
Palestinians.
electricity,
But any
and
genuine
civilian
effort
infrastructure,
to understand the
as
cause
well
of this
as
toll
over key government
must
functions.
take account of the
Entry
horrendous
and
reality
exit by
created
air and
by
sea to
Hamas
Gaza is
within the
strictly
Gaza Strip.
prohibited. With Israel
When Israel
operating the
withdrew
only two crossing
all its
points,
soldiers and civilians from Gaza
given that
in
continuing effective
2005,
control
it left
by
a
Israel
coastal
and
area
over the
with the
territory of
potential
Gaza,
to become
Israel
a
is still
political and
considered by
economic
international
success story.
community to be under
Hamas's
belligerent
violent
occupation
takeover in
by Israel.
2007 changed all
South
that.
Africa unequivocally
Over the
condemned
past
the
16 years of
targeting
its rule,
of civilians by
Hamas has
Hamas
smuggled countless
and
weapons
other
into Gaza
Palestinians armed groups
and has diverted
the
billions
taking
in
of
international
hostages
aid,
on the 7th of
not to build
October
schools,
2023.
hospitals, or
And has
shelters to
again
protect its
expressly
population
recorded these
from the
condemnations,
dangers of the attacks
mostly recently
it launched
in
against
its
Israel over
note
many years,
to Israel on the
but
21st
rather
of
to turn massive
December
swaths of the
2023.
civilian infrastructure
That said,
into perhaps the most
no
sophisticated
armed attack
terrorist stronghold
on a state
in the history
territory,
of
no
urban
matter
warfare.
how serious, even an attack involving atrocity
Remarkably,
crimes,
counsel for the
can
applicant
provide any
described the
justification
suffering
for
in Gaza
or
as
defense
unparalleled
to
and
breaches to the
unprecedented,
convention,
as if
whether
they
as
are
a matter
unaware
of
of
law
the utter
or morality.
devastation wrought in wars
Israel's
that have
response to the
raged
7th of
just in
October
recent years
2023
around the world.
attack has crossed this
Sadly,
line and give rise
The civilian
to the breaches
suffering in
of the
warfare
convention.
is not unique to
Faced with
Gaza.
such evidence and our
What
duty
is
to do what
actually
we can do to
unparalleled
prevent
and
genocide,
unprecedented
as
is the
contained in
degree to
Article
which
1 of
Hamas
the
has entrenched
Convention,
itself
the South
within
African
the civilian
government
population
initiated this
and
case.
made Palestinian civilian
South
suffering
Africa
an
welcomes
integral
the
part of
fact
its
that
strategy.
Israel has engaged with the case
Hamas has
in order to
systematically
have the
and
matter
unlawfully
resolved by the court.
embedded its military
After careful and
operations,
objective consideration of the
militants and
facts
assets
and
throughout
submission
Gaza,
put before
within
it,
and beneath
as the
densely
parties to the
populated civilian
convention
areas.
have intended.
It has built an extensive
This
warren
hearing
of
is
underground
is
tunnels
concerned
for its
with
leaders and
South Africa's
fighters,
request to the court
several
for
hundred
the
miles in length,
indication of
throughout
provisional
the
measures,
Strip,
and will
with
necessarily have
thousands
a
of
narrow
access points
and particular
and terrorist
focus.
hubs located in
I invoke
homes,
the words of Martin
mosques,
Luther King when he
UN
said,
facilities,
"The arc
schools,
of the moral
and
of the
perhaps most
universe
shockingly,
is long,
hospitals."
always bending
This is
towards
not an
justice."
occasional tactic.
South Africa's
It
case
is an
will be presented
integrated,
by a team of 6
pre-planned,
legal counsels,
extensive and
comprising
abhorrent
of
method
Dr.
of warfare,
Adila Asim, Mr.
purposely
Tembeka
and
Ngugaitobi,
methodically murdering
Professor John
civilians,
Dugat,
firing
Ms.
rockets
Blin
indiscriminately,
Licron,
systematically
Max de
using
Vries,
civilians,
and Professor
sensitive sites,
Wagan Low.
and civilian objects as
Dr.
shields,
Adila Asim, Senior
stealing
Counsel,
and hoarding
will
humanitarian
provide an
supplies,
overview of the risk of
allowing those under
genocidal
its
acts
control to
in the
suffer,
perpetual vulnerability
so
to
that it
acts
can
of
fuel its
genocide.
fighters and
Mr.
terrorist
Tembeka
campaigns.
Ngugaitobi, Senior
The
Counsel,
appalling
will
suffering of
examine
civilians,
Israel's alleged
both Israeli
genocidal
and
intent.
Palestinian,
Professor
is
John
first and
Dugat,
foremost
Senior Counsel,
the result
will
of
focus
this
on the prima
despicable
facie
strategy.
jurisdiction.
The horrible
Professor
cost
Max
of
du Plessis,
Hamas not
Senior
only failing
Counsel,
to protect
will
its
discuss the
civilians,
various rights
actively
currently
sacrificing
under
them
threat.
for its own
Blinny,
propaganda and military
Crown,
benefit.
King's Counsel
And if Hamas abandons this strategy,
will present the argument of
releases the
agency
hostages,
and potential
lays down its
irreparable harm,
arms,
and Professor
hostilities and
Wagan Low,
suffering
King's
would end.
Counsel, will speak on
Madam
the provisional
President, members
measures.
of the court,
I now request, Madam President,
there are
the
many
court
distortions
to call
in the
on
applicant's
Dr.
submission to
Hassim.
the court.
I thank you.
But as shall be demonstrated by
His
counsel,
Excellency, Mr. Lamola.
there is one
and I now
that overshadows
invite
them all.
Ms. Adila Hassim to address
in the
court.
applicant's
You have the
telling,
floor, Madam.
it is almost as if there is no intensive armed conflict taking place between two parties at all. No grave threat to Israel and its citizens. Only an Israeli assault on
Madam
Gaza.
President,
The court is
distinguished members
told
of the
of
court,
widespread damage to buildings.
it is a privilege
But it is
to
not
appear on
told,
behalf
for
of the
example,
Republic of South
how many
Africa in this
thousands of those
case
buildings were
of
destroyed
exceptional importance.
because they were booby-trapped by
It's
Hamas.
a case that
How many became
underscores
legitimate
the very
targets
essence
because of the strategy
of our
of using civilian
shared
objects
humanity
and protected
as
sites
expressed
for military
in the
purposes?
preamble to the
How many
Genocide
buildings were
Convention.
struck
It's
by
my
over
task
2,000
to address
indiscriminate
the
terrorist
court on the
rockets
genocidal
that
acts
misfired and
that have
landed in
led to
Gaza
this
itself?
urgent request for provisional
The
measures
court is told of
under
over
Article
23,000
41
casualties.
of the Statute of the Court.
As the applicant repeats,
South Africa
as many have,
contends that
unverified
Israel has
statistics
transgressed
provided by
Article 2
Hamas
of the
itself,
Convention
hardly a
by
reliable
committing
source.
actions that fall
Every
within the
civilian
definition
casualty
of
in this
genocide.
conflict is a
The
human
actions
tragedy
show
that demands
systematic
our
pattern
compassion.
of conduct from which
But the court
genocide
is not
can be
told
inferred.
how many thousands of casualties
Allow
are in
me
fact militants.
to place these acts
How many
in
were killed by
context.
Hamas fire?
Gaza
How many were
is
civilians
one
taking
of the
direct
two
part in
constituent
hostilities?
territories
And
of the
just how many
occupied
are the result
Palestinian territories
of legitimate and
occupied
proportionate
by Israel
use of force
since
against military
1967.
targets, even if
It
tragic?
is a narrow strip of
And the court
approximately
is also told
365
of the dire
square
humanitarian situation in
kilometers,
Gaza.
as depicted in the
But
map
it is not told
now
of
displayed.
Hamas's practice of stealing and hoarding aid.
Israel
It
continues
is not
to
told of the
exercise
extensive Israeli
control
efforts to
over
mitigate
the space,
civilian harm, of the humanitarian
territorial
initiatives
waters,
being undertaken
land crossings,
to enable the flow of
water,
supplies and provide
electricity,
medical attention to the wounded.
electromagnetic sphere,
The applicant
and civilian
purports to describe the
infrastructure in
reality in
Gaza,
Gaza.
as well as
But
over
it is as
key
if
governmental
Hamas
functions.
and its total contempt for
As
civilian
the
life
Honourable Minister
just do not
has
exist
said,
as a direct
entry
cause of
and
that
exit
reality.
by air
Hamas
and
is
sea to
widely
Gaza
estimated
is
to have over
prohibited
30,000
with
fighters
Israel operating the only two
and
crossing
is known
points.
to bring minors no older than
Gaza,
15 or 16
which is
into
one
its
of the
ranks.
most densely populated
They are
places in
coming
the
for
world,
us.
is home to
But in South
approximately
Africa's telling,
2.3 million
they have all but
Palestinians,
disappeared.
almost half of them
There are no
children.
explosives in mosques and
For the
schools
past
and children's
96
bedrooms.
days, Israel
No
has
ambulances
subjected
used to
Gaza
transport
to what has been
fighters.
described
No tunnels
as
and
one
terrorist
of the
hubs under
heaviest
sensitive
conventional
sites.
bombing
No
campaigns
fighters
in the
dressed as
history of
civilians.
modern warfare.
No commandeering of aid
Palestinians
trucks.
in Gaza are
No
being killed by
firing
Israeli
from
weaponry
civilian homes,
and bombs
UN facilities,
from air,
and even safe zones.
land, and
There is
sea.
only Israel acting in Gaza.
Also, at
The
immediate
applicant is
risk
essentially
of
asking the
death by
court
starvation,
to substitute the lens of
dehydration,
armed conflict
and disease
between a state
as a
and a lawless
result of
terrorist
the ongoing
organization
siege by Israel,
with the lens of
destruction
a
of
so-called
Palestinian
genocide
towns,
of a
the
state
insufficient
against a civilian
aid being allowed
population.
through to the
But it is
Palestinian
not offering
population,
the court a lens.
and the impossibility
It is offering it a
of
blindfold.
distributing this limited aid
Madam
while
President,
bombs fall.
members of the court,
This conduct
the nightmarish environment
renders
created by
essentials
Hamas
to life
has been concealed by the
unobtainable.
applicant. But it is the
At this
environment in which
provisional
Israel is
measures
compelled to
stage,
operate.
as this court has
Israel
made
is
clear
committed, as it
in the
must
Gambia-Myanmar
be, to comply
case,
with the law.
it is not
But it does so
necessary
in the face
for the
of
court to
Hamas's
come to
utter
a
contempt
final
for the law.
view on the question of whether
It is
Israel's
committed,
conduct
as it must be,
constitutes
to
genocide.
demonstrate humanity.
It is necessary to
But it does
establish
so
only
in the face of Hamas's
whether
utter
at least
inhumanity.
some of the acts alleged
As will be
are
presented
capable
by
of
counsel,
falling within the
these
provisions
commitments are a
of the
matter of
Convention.
express government policy.
On
military
analysing the
directives and
specific
procedures.
and ongoing
They
genocidal
are
acts
also an
complained
expression of Israel's core
it is
values.
clear that at least some,
And as shall
if
also
not
be
all
shown,
of these acts, fall
they are matched
within
by
the
genuine measures on
Convention's
the ground
provisions.
to mitigate civilian
These
harm
acts are
under the
documented
unprecedented
in detail
and
in
excruciating
South
conditions
Africa's,
of warfare
application
created by Hamas.
and confirmed by
It is
reliable,
plainly inconceivable,
often UN
under the
sources.
terms set by this very court,
It's thus
that
unnecessary
a state conducting
and
itself in
impossible
this
for me to
way,
recount all of
in
them.
these circumstances,
I will highlight only
may be
some
said to be engaged in
in order
genocide.
to illustrate
Not even
the
prima
pattern
facie.
of genocidal conduct.
The key component of genocide,
The UN
the
statistics
intention to destroy a
that are
people
relied
in
upon
whole or in
are up to
part,
date
is
as
totally
of
lacking.
9 January
What Israel
2024.
seeks by operating in Gaza is not to
In South
destroy
Africa's
a
oral
people,
submissions, we will
to
illustrate the
protect the
facts
people,
that we rely on
its people,
with limited use
who are under
of
attack
audiovisual
on multiple
material.
fronts, and to
Madam
do so in
President,
accordance
we do
with the
so
law
with restraint
even as it faces a
and
heartless
only where
enemy
necessary,
determined to use
and
that very
always with
commitment
respect
against it.
to the Palestinian people.
As will be detailed by Council,
Against this
Israel's
background,
lawful aims
I
in
move now
Gaza
to demonstrate
have been clearly and repeatedly
in turn
articulated
how
by its Prime
Israel's
Minister,
conduct violates
its Defence Minister,
Articles
and all members of
2A,
the War Cabinet.
2B,
As the Prime Minister reiterated yet
2C,
again this week,
and 2D
Israel is
of the
fighting Hamas
Convention.
terrorists, not the civilian
The
population.
first genocidal
Israel
act
aims to ensure
committed by Israel
that Gaza
is
can
the
never
mass
again be
killing
used
of
as a
Palestinians in
launchpad for
Gaza,
terrorism.
in violation
As
of
the Prime
Article
Minister
2A of the
reaffirms,
Genocide Convention.
Israel seeks neither to
As
permanently
the UN
occupy
Secretary
Gaza
General
or
explained
to displace
5
its civilian
weeks ago,
population.
the level
It
of
wants to create
Israel's
a better
killing
future
is so
for Israelis
extensive
and Palestinians
that
alike,
nowhere
where
is
both
safe
can live in peace,
Gaza.
thrive and prosper,
As I stand
and where
before
the
you
Palestinian
today,
people have all the power to govern themselves, but not the capacity to threaten
23,210
Israel.
Palestinians have been
If there
killed
is a threat
by
to that
Israeli
vision,
forces
If
during
there
the
is a
sustained
humanitarian
attacks
threat
over the last
to the
3
Palestinian
months.
civilians of Gaza,
At least
it stems primarily
70%
from the
of
fact that they have
whom are
lived under the
believed
control
to be
of a
women
genocidal
and children.
terrorist organization
Some
that has total
7,000
disregard for
Palestinians
their
are
life
still
and
missing,
well-being.
presumed dead
That organization,
under the rubble.
Hamas, and its sponsors seek to deny Israel, Palestinians, and Arab states across the region
Palestinians in Gaza are
the ability
subjected
to advance a
relentless
common
bombing
future
wherever
of
they go.
peace,
They are
coexistence,
killed in their homes,
security, and
in places
prosperity.
where they seek shelter,
Israel
in
is in a war of
hospitals,
defense against
in
Hamas,
schools,
not against the Palestinian
in
people,
mosques, in
to
churches,
ensure that they do not succeed.
and as they try to find food and
In these
water for
circumstances,
their families.
there can hardly be a
They have
charge
been
more
killed if they
false
failed to
and more
evacuate
malevolent than the allegation against Israel of
in the
genocide.
places to which they
The
have
applicant
fled,
has regrettably
and
engaged
even
in
while
a
they
transparent
attempted
attempt
to flee
to
along
abuse the
Israeli
Convention's
declared
compulsory jurisdiction
safe routes.
mechanism, and in
The level
particular
of killing is so
the provisional measures
extensive
phase of
that those
proceedings
whose bodies are
to bring
found are
under the
buried
purview of
in
the court
mass graves,
matters over which,
often
in truth, it lacks
unidentified.
jurisdiction.
In the
Madam
first 3
President,
weeks alone,
members of the court,
following
the
7
Genocide
October,
Convention
Israel
was a solemn
deployed
promise
6,000
made to the Jewish people
bombs per
and to all
week.
peoples of never
At
again.
least 200 times
applicant, in
it has
effect,
deployed
invites the court
2,000
to betray that
pound
promise.
bombs
If the
in
term
southern areas
genocide
of
can be so
Palestine
diminished
designated
in the
as
way that
safe.
it advocates, if
These
provisional
bombs
measures
have
can
also
be triggered
decimated the north,
in the way that it
including
suggests,
refugee camps.
the convention becomes an
2,000
aggressor's
pound
charter.
bombs
It will
are some of
reward,
the biggest
indeed
and
encourage,
most
the
destructive
terrorists
bombs
who hide
available.
behind civilians
They are
at
dropped
the expense of
by
the states
lethal
seeking
fighter
to
jets
defend against them.
that are used to strike targets
To
on the
maintain
ground
the integrity
by one
of the
the
Genocide
world's
Convention.
most resourced armies.
To maintain its promise.
Israel
and the court's
has
own
killed
role as
an
its guardian.
unparalleled and
It is respectfully
unprecedented
submitted
number of
that the
civilians
application and
with the full
request
knowledge
should be
of how many
dismissed for what they
civilian
are,
lives each
a
bomb
libel.
will take.
designed to deny
More
Israel
than
the right to defend itself
1,800
according to the
families,
law
Palestinian families
from the
in Gaza,
unprecedented terrorist
have lost
onslaught
multiple
it
family
continues to
members,
face,
and hundreds of
free the
multi-generational families have been
136
wiped
hostages
out, with
Hamas
no remaining
still holds.
survivors.
I
Mothers,
thank you for your kind attention.
fathers,
May I ask,
children,
Madam President,
siblings,
that you call Professor Shaw to the podium.
grandparents, aunts,
I thank the
cousins,
co-agent of Israel for his
often
statement,
all
and I now
killed
invite
together.
Professor Malcolm Shaw.
This
Floor.
killing
Have the floor.
is nothing short of destruction of Palestinian life. It is inflicted deliberately. No one is spared, not even newborn babies. The scale of Palestinian child killings in Gaza is such that UN chiefs have described it as a graveyard for children.
Madam President,
The devastation
and members of the court,
we submit is
it
intended
is a great honour to appear
is
before you
intended
again,
to and has laid
and a
waste
privilege
to Gaza
to appear on
beyond any
behalf of the State
acceptable
of Israel.
legal, let alone
It is my
humane
task today
justification.
to address the issues falling within the general categories
The second
of prima
genocidal
facie
act
jurisdiction
identified in South
and the
Africa's
preservation
application
of alleged rights
is
sought to be
Israel's
protected.
infliction of serious
However,
bodily
I would like
or mental
first to
harm
make a
to
preliminary
Palestinians in
comment about
Gaza
the
in
key
violation
question
of
of
Article
context.
2B
It
of the Genocide
constitutes the
Convention.
framework for the consideration of this
Israel's
request
attacks
for the
have
grant
left
of
close to
provisional
60,000 Palestinians wounded
South
and maimed.
Africa casts
Again,
its net
the
widely.
majority of
In its
them women and
application,
children.
It uses the word context
This,
many
in
times.
circumstances where the healthcare
In
system
particular,
has
it
all
declares
but
that
collapsed.
It is important
return
to
to
place
this
the
later
acts
in my
of
speech.
genocide in the broader
Large
context
numbers of Palestinian
Israel's
civilians,
conduct
including
towards
children,
the Palestinians
are arrested,
during its
blindfolded,
75-year
forced to
long
undress
apartheid.
and loaded onto trucks,
Leaving aside
taken
the
to
outrageous
unknown
nature of that
locations.
statement, why stop at 75 years?
The suffering of the
Why not
Palestinian
refer to
people,
1922
physical and mental,
and the
is
approval by the
undeniable.
Council of the League of Nations of the British Mandate?
Turning to the third genocidal
1917,
act under
the
Article
proclamation of the
2C.
Balfour Declaration.
Israel has
Maybe
deliberately
also
imposed
include
conditions
the
on
entry into
Gaza
the
that
land
cannot
of
sustain life
Israel
and are
of the
calculated to bring
Israelite
about its
tribes
physical
some
destruction.
3,500 years ago.
Israel achieves this in at least
The immediate
four
and
ways.
proximate context for the
First,
specific allegations
by
of
displacement.
genocide claimed by
Israel
South
has
Africa lies in the events
the
of the 7th
displacement
of October,
of about
when Hamas
85% of
militants and
Palestinians
other armed
in
groups and
Gaza.
individuals
There is nowhere
stormed
safe
into
for them
the
to flee
internationally
to.
recognized
Those who cannot
sovereign
leave or
territory
refuse
of
to be
Israel
displaced have either been
and
killed
committed acts
or
of
at
barely
extreme risk
credible
of being killed in
atrocity.
their homes.
It was these events
Many
that truly constitute
Palestinians
the real context
have been
for South
displaced
Africa's allegations.
multiple times.
Indeed, such
As
acts may be
families are
seen
forced to move
as the real
repeatedly
genocide in this
search of
situation.
safety.
As
Israel's
the President
first
of the
evacuation
European
order
Commission put
on
it on
13
the
October
19th of October,
required the evacuation of over
there was
1
no
million
limit
people,
to the blood Hamas
including
terrorists
children,
wanted to spill.
the elderly,
They went home by home.
the wounded,
They burned
and
people
infirm.
alive. They mutilated
Entire
children
hospitals
and even babies.
were required
Why?
to evacuate
Because they
even
were
newborn
Jews.
babies in intensive
Because they were
care.
living in the state of Israel.
The order required
And
them to
Hamas's
evacuate
explicit
the
goal
north
is to eradicate
to the south
Jewish life from
within
the Holy
24
Land.
hours.
These terrorists,
The
supported by
order
their friends in
itself
Tehran,
was
will
genocidal.
never stop.
It required
And so
immediate
Israel
movement,
has the right to
taking
defend itself
only
in
what could be
line
carried,
with humanitarian
while
law.
no humanitarian assistance was
Of course,
permitted, and fuel, water,
These
and food,
atrocities do
and
not
other
justify
necessities of
violations
life
of the law
had
in
deliberately
reply.
been cut off.
Still less genocide.
It was clearly calculated to bring
But
about
they
the
do
destruction of the
justify,
population.
mandate even, the exercise
For
of
many
the legitimate
Palestinians,
and
the
inherent
forced
right of a
evacuation
state
from their
to
homes
defend
is
itself,
inevitably permanent.
as enshrined
Israel has
in the
now
UN
damaged
Charter
or destroyed an
and under
estimated
customary international
355,000 Palestinian
law.
homes,
To put an end
leaving at
to
least
the continuing
500,000
attacks against
Palestinians
it and
with
to
no
prevent
home
them
to
from
return to.
succeeding.
The Special
A threat that has been
Rapporteur
made
on the human rights of internally
explicitly by
displaced
Hamas
persons
and repeated,
explains
and it is
that
thus
houses
real
and infrastructure,
and imminent.
quote, have been razed
This
to the
context
ground,
is critical,
frustrating any
for it shows
realistic
that the true
prospects
nature of the
for
situation
displaced Gazans to
as it-
return
as
home,
it has unfolded,
repeating a long history of
particularly the
mass
7th of
forced
October,
displacement
is that
of
of an armed
Palestinians by
conflict.
Israel.
A heavily armed militia and its allies
There is no indication at all
precipitated egregious
that Israel
hostilities,
accepts responsibility
and the consequences
for rebuilding
lie everywhere.
what it has
Point is
destroyed.
this, armed
Instead,
conflict,
the
even
destruction
when fully
is
justified
celebrated by the
and
Israeli
conducted
army.
lawfully, is brutal
Soldiers
and costs lives.
film themselves joyfully
Particularly when the
detonating
militia in
entire
question
apartment blocks and town
specifically
squares,
targets civilians
erecting the
and
Israeli
civilian
flag
facilities,
over the wreckage,
and when it is patently
seeking to re-establish
unconcerned
Israeli
about
settlements
causing civilian
on the rubble
casualties
of Palestinian
on its own
homes,
side.
and thus
Conflict
extinguishing
is also
the
regulated
very
by law,
basis of
the rules and
Palestinian life in
principles
Gaza.
of international humanitarian law,
Second,
under the Hague Regulations,
together
the
with the
Geneva
forced
Conventions
displacement,
of 1949,
Israel's
and
conduct has
customary
been
international
deliberately
law.
calculated
These are well
to cause
developed
widespread
and applicable
hunger,
and are fully
dehydration,
respected
and
by
starvation.
Israel.
Israel's campaign has pushed
Such rules
Gazans
cover
to the brink of
permitted
famine.
activities and international
An unprecedented
humanitarian law,
93%
where
of the
civilian
population
damage
in
and
Gaza
loss,
is
always
facing
to be regretted,
crisis levels of hunger.
are caused in the legitimate pursuit
Of all
of
the
military
people
objectives
in the world
through to the violation of the law,
currently suffering
being
catastrophic
grave
hunger,
breaches of the Geneva
more than
Conventions and up to
80%
war crimes
are in
and
Gaza.
crimes against humanity. However,
the situation is such
the
that
only
the experts
category
are now
before this
predicting
court is
that
genocide.
more Palestinians in Gaza
Not
may
every
die from
conflict is
starvation
genocidal.
and disease than
The crime of
airstrikes.
genocide in international
And yet
law
Israel
and under
continues
the
to
Genocide
impede the
Convention
effective
of
delivery of
international
humanitarian
law
assistance
is a
to
uniquely
Palestinians,
malicious
not only refusing to
manifestation.
allow sufficient
It stands
aid
alone
in,
amongst the
but
violations
removing
of
the
international
ability to
law
distribute
as
it
the epitome
through
and
constant
zenith
bombardment
of evil.
and obstruction.
It has been described
Just
correctly
3 days
as the
ago,
crime of crimes, the
on 8
ultimate
January,
in wickedness.
a planned mission by
Indeed, the
UN
court itself
agencies to deliver
emphasised in
urgent
its order
medical
of the 2nd of
supplies
June
and vital
1999
fuel to
that
a
the threat
hospital
or
and
use
medical
of force
supply center
cannot in itself
was
constitute
denied
an act of
by
genocide
Israeli
within the meaning of
authorities.
Article 2 of the
This
Geneva
marked
Convention,
the 5th denial
and
of a
particularly
mission to the
instant
center
bombing
since
as lacking
26
the element
December,
of intent in the
leaving
circumstances.
5 hospitals in northern
put it
Gaza
another
without
way,
access to
If
life-saving
claims of
medical
genocide were to
supplies
become
and equipment.
the common currency of
Aid
armed
trucks
conflict,
that are allowed
whenever and
in
wherever
are seized
that
upon
occurred,
by the hungry.
the
What is
essence
provided
of this crime would be
is simply
diluted
not
and lost.
enough.
I turn now to the question of the prima facie jurisdiction of the court in the matter before us.
Madam President, members of the
Article
court,
9
this
of
is
the
an image
Genocide
of an aid
Convention,
truck
to which both
arriving in
states
Gaza.
are parties without reservation, makes the court's jurisdiction
Israel has
conditional
deliberately
on the
inflicted
existence
conditions
of a dispute
in which Palestinians in
relating
Gaza
to the
are denied
interpretation,
adequate
application,
shelter,
or
clothes or
fulfillment of the
sanitation.
Convention.
For weeks,
And the
there have
relevant
been
date
acute
for
shortages
determining
of
the
clothes,
existence of
bedding,
such a
blankets and
dispute
critical non-food
is the
items.
date on which the application
Clean
is
water
submitted to
is
the court.
all but gone, leaving
Whether or not a
far
dispute
below
in
the
these
amount
terms
required
exists
to
at the
safely
time of the
drink,
filing of the
clean
application
and cook.
is a matter for objective
Accordingly,
determination.
The
by
WHO
court.
has
It is a
stated
matter of
that
substance
Gaza
and not
is
a question
experiencing
of form
soaring rates of infectious
procedure.
disease
The
outbreaks.
court will take into
Cases
account
of diarrhea in children
particular
under 5
any
years of
statements
age
or
have
documents
increased
exchanged between the parties, as well as any
2,000%
exchanges made in
since
multilateral
hostilities
settings,
began.
the court has said.
When combined and left
The key
untreated,
point here
malnutrition
is the use of the term
and disease create a
exchange
deadly
between the
cycle.
parties. Unilateral assertion does
The
not
Fourth Genocidal
suffice.
Act,
There needs to be some
under
element
Article
of
2B,
engagement between
is
the parties.
Israel's military assault
The
on
element of
Gaza's healthcare
interchange
system,
and bilateral interaction
which renders life
is required.
unsustainable.
A dispute is a reciprocal
Even by 7
phenomenon.
December,
This point has been
the UN Special
consistently
Rapporteur
noted by the
on the
court.
right to health noted
For example, the court
that the
reaffirmed
healthcare
in
of
the
infrastructure
Myanmar
in the
case
Gaza Strip
the view
has
that
been
it had
completely
expressed earlier,
obliterated.
that in order for a dispute in the
Those
sense
wounded
of
by
Article
Israel
9
in
to
Gaza
exist,
are being deprived
it
of
must be shown
life-saving
that
medical
the claim
care.
of one party
Gaza's healthcare system,
is positively
already crippled
opposed
by years of
by the
blockade
other.
and prior
The
attacks
court
by Israel,
further referred
is
in the
unable to
Marshall
cope
Islands cases
with the sheer scale
to
of
the
the
need that
injuries.
the respondent should not be deprived of the
Finally,
opportunity to
The
react
UN Special Rapporteur on
before
Violence Against Women
the
and
institution
Girls
of
has pointed to
proceedings
acts
to the claim made
committed
against
by
its own
Israel
conduct.
that would fall under
Where
the,
a state
under the
makes an
fourth
assertion
category of
concerning the
genocidal
conduct
acts
of another state,
in Article
it
2D
must thus give
of the
the
Convention.
latter a reasonable opportunity
On 22
to
November,
respond before
she expressly
resorting
warned
to litigation,
the following.
particularly in a matter of
The
such
reproductive
severity
violence
as an accusation of
inflicted
genocide,
by Israel on
and
Palestinian
particularly
women,
before a court of
newborn
this
babies,
standing,
infants
and it
and
behoves
children
that state
could be
to
qualified
provide
as
supporting
acts of
evidence
genocide
of
under
some
Article 2
credibility.
of the Genocide Convention,
Here, South
including
Africa cites
imposing
only a
measures
couple of
intended
general
to prevent
public statements
births
by Israel,
within a group.
referencing merely a press report by Reuters.
Israel
and a
is blocking
publicity
the
release
delivery of
from the
life-saving
Israeli
aid,
Ministry of Foreign
including
Affairs.
essential medical kits for
These
delivering
responses
babies
were not addressed directly
in
or even
circumstances where an
indirectly
estimated
to South Africa.
180
There is
women
no evidence
are giving
of
birth in
positive
Gaza
opposition
each
as
day.
required by the court.
of these
Further,
180 women,
South Africa cites
the
no relevant exchange
WHO
between the
warns
parties,
that
which would be the
15%
normal
are likely
fashion for the
to
expression
experience
and determination
pregnancy
of a
or
dispute
birth-related
between states.
complications and need
This
additional
actually
medical
typifies
care.
how South Africa has
That
approached this
care
matter.
is
It
simply
seems to
not
believe
available.
But it does not take two to tango. It is sufficient if one state
In
determines
some,
there
Madam
is a
President,
dispute, leaving
all
the
of
other
these
party
acts,
flummoxed.
individually and
Professor
collectively,
Dugard
form
explains
a
that South
calculated
Africa had
pattern of
voiced its
conduct
concerns in
by
the Security
Israel,
Council and
indicating
in public
a
statements,
genocidal
and
intent.
and had further referred the
This
matter
intent
to
is
the
evident from
International
Israel's
Criminal
conduct
Court.
in
At that point, he says,
specially
it became clear
targeting
there was a serious
Palestinians
dispute
living
between
in
the two
Gaza,
states.
using
The court
weaponry
has emphasised
that
that in the
causes
case of statements made by
large-scale
one state
homicidal
in a
destruction,
multilateral forum, the court
as well
must
as
give
targeting
particular attention
targeted
inter alia
sniping of
to the
civilians,
content of a party statement
designating safe
and to the
zones
identity
for
of the
Palestinians
intended
to seek refuge,
addressees
and then
in
bombing
order to
these,
determine whether that statement,
depriving
together
Palestinians
with
in
any
Gaza
reaction
of basic
thereto,
needs, food,
show that
water,
the parties before it
healthcare,
held
fuel, sanitation,
clearly opposite views.
and communications,
South Africa's actions
destroying
were
social
insufficient.
infrastructure,
Indeed, in the
homes,
Marshall Islands cases,
schools,
the court, referring specifically
mosques,
to a statement
churches,
made at a conference,
hospitals,
noted that
and
it did not call for a specific
seriously
reaction by
injuring
the UK,
and leaving large numbers
and
of
thus
children
no
orphaned.
opposition of views can be inferred from the absence of
Genocides
any
are never
such
declared in
reaction.
advance.
Specific
But this
reaction.
court has the benefit of the
It
past
is thus
13 weeks of
disingenuous for
evidence
Professor Dugard
that shows
to conclude
incontrovertibly a pattern
Israel
of conduct
must have been aware
and
from
related
South
intention
Africa's public
that
statements,
justifies
démarches,
a plausible
and referral
claim
to the ICC of
of
Israel's
genocidal
genocidal acts, that a dispute
In the
existed between
Gambia-Myanmar
the two
case,
states.
this court did
This
not
is not a
hesitate
dispute.
to
It
impose
is a
provisional measures
unispute,
in relation
a
to
one-sided
allegations
clapping
that
of hands.
Myanmar
Professor Dugard
was committing
perhaps tries to
genocidal
retrieve
acts
the
against the
situation
Rohingya
by declaring
within
that
the Rakhine state.
special considerations
The facts
apply to
before
the
the court
existence
today
of disputes
are
concerning
sadly
Article 9,
even more stark,
without telling
and
us
like the
what those
Gambia-Myanmar
conditions
case,
could possibly be.
deserve and demand this court's
We
intervention.
come now to the rather bizarre
Every day
story
there is
of the
mounting
exchange of
irreparable
note verbal.
loss of life,
Professor
property,
Dugard would have us believe
dignity,
that such
and
exchanges
humanity for the
are merely
Palestinian
a
people.
matter of courtesy,
Our
of little
news
real
feeds
consequence.
show graphic
This
images
is
of
not the
suffering
normal understanding
that has
of
become
such
unbearable
notes
to watch.
and their importance in
Nothing
international
will stop
relations.
the suffering
But he says
except an
this
order
for
from
a
this court.
reason, as we
Without
shall
an
see.
indication of provisional measures,
South
the
Africa
atrocities will
instituted
continue,
proceedings against
with the
Israel
Israeli
on
Defense
the 29th
Force
of December.
indicating that it intends
In its
pursuing
long
this course of
recital,
action
the
for at least
application
a year.
notes that on the 21st of December,
In the words of the
South
UN
Africa
Under-Secretary
sent a note
General
verbal to
on
Israel
5 January
raising its concerns about
2024,
genocide in
I
Gaza.
quote,
The application further states
"You
that
think getting
Israel
aid into
has not
Gaza is
responded
easy?
directly to South
Think again.
Africa's note verbal.
3 layers of inspections
is
before
incorrect.
trucks can even
Israel
enter.
did indeed respond
Confusion
that very day,
and long queues.
informing South
growing
Africa that
list
the
of
note
rejected
verbal
items.
has been forwarded to
A
capital
crossing point
and that a
meant for
response was
pedestrians,
expected
not
shortly.
trucks. Another crossing point where
South
trucks have
Africa
been
confirmed
blocked
the
by
next day
desperate,
that it
hungry
had received
communities.
the message.
A
On
destroyed
the
commercial
26th of
sector.
December, the Director General of Israel's Ministry of
Constant
Foreign
bombardments,
Affairs proposed
poor
to his
communications,
counterpart in the Department of
damaged
International
roads,
Relations and
convoys
Cooperation
shot
of South
at,
Africa by
damaged
text to schedule
delays
a
at
meeting
checkpoints,
at his earliest
a
convenience
traumatized and exhausted population crammed into a smaller and smaller sliver of land.
December, the embassy sent to South
Shelters
Africa by email
which have
a
long
note
exceeded
verbal
their full
suggesting
capacity.
a meeting of respective
Aid workers
Directors General
themselves
at the earliest
displaced,
convenience
killed.
in order to discuss
This
the issues
is an
raised.
impossible situation for the people of
An attempt by the
Gaza and
embassy
for those trying to help
deliver the
them.
note was
The
refused
fighting
due
must
to
stop.
a national holiday, and the
Close
South African
quote.
Department of International Relations
Madam President,
specifically advised the embassy
members of the court,
on the 28th of
that
December
concludes my
to
section
hand-deliver
on the
note
genocidal
on the
conduct
2nd
of Israel.
January.
I thank you for your
The
patient
application
attention.
was
And I ask that
instituted
you call
on the 29th
Advocate
of December.
Mukatobi to the podium to
This was an
address the
attempt by
court
the State
on
of Israel in
genocidal
good
intent.
faith to open a dialogue
I
and
thank
discuss
Ms.
South Africa's
Hassim, and I
concerns.
now invite Mr. Tembeka
However,
Nukatobi
not only
to
was
address the
this
court.
ignored
Have
at
the
the
floor,
relevant time, but South Africa proceeded to institute proceedings the following day and declared in its application that no reply had been received to its note verbal, which was patently
Madam President
not the
and
case.
distinguished members of the court,
Perhaps realizing the effect
it is
of
a
this,
privilege to appear
South
before the
Africa, with
court
some
on
haste,
behalf of South Africa.
sent a note verbal
I will
on the
address
4th of
Israel's
January,
genocidal
which
intent.
essentially just repeated
At
the
this
contents
stage,
of the note of the
The court
21st
is not
of
required
December,
to determine that
but
the
it
only
explained the
inference
following day in
to
a
be
letter
drawn
to the
from the
registrar
available evidence
that the
is
Israeli note had
genocidal,
not been
to order
received
provisional measures,
by the
as that is to
appropriate
decide
team.
the merits.
Israel has proof
Rather,
of receipt.
the assessment of
It's
the
also
existence
stated
of
that the
an
dispute is
intent to
plainly not
destroy
capable of resolution
could be made
by
by
way
the
of a
court
bilateral
only at
meeting.
the stage of the
Nevertheless,
examination
it
of the
suggested
merits.
to hold a meeting the
That
next
some
morning.
of the
Israel
alleged
replied
acts
the next morning,
may also amount
expressing
to
surprise that
atrocities
South
other
Africa
than
had
genocide
instituted
does not
proceedings
exclude
without taking
the
up
finding
the
of
sincerely
plausible
made
acts
offer to hold
of genocide.
consultations and convey
Madam President,
its wish for discussion
South Africa
to be
is
held
not alone
following the close of
in
these
drawing
oral
attention
hearings.
to Israel's
South Africa,
genocidal
in a note
rhetoric
dated the 10th of
against
January,
Palestinians in
summarily
Gaza.
and surprisingly, in the
15
circumstances,
United
said there was
Nations
no
special
point in such a
rapporteurs
meeting.
and
Curious
21
indeed.
members of the United Nations
Africa
working
decided
groups have warned
unilaterally
that
that
what
a
is
dispute
happening in
existed,
Gaza
irrespective
reflects a
of
genocide
Israel's
in the making
conciliatory and friendly response
and an overt
since
intent
repeated.
to destroy the Palestinian
Perhaps had
people
South Africa
under
taken up this
occupation.
offer at the time proffered as a result of
Israel
its own note,
has a
the parties
genocidal
may have
intent
decided there was no
against the
dispute as
Palestinians
such
in
to place
Gaza.
before the court under the
That is
Genocide
evident
Convention.
from the way in which
And that
Israel's
South
military
Africa's
attack
expressed
is being
concerns
conducted,
over the genocide
which has been
allegations would have
described
been
by Ms.
assuaged.
Hassim
We may
SC.
never know.
It
South
is
Africa's
systematic in its
precipitate
character and
institution
form.
of proceedings
The mass
foreclosed
displacement
that
of the
option.
population of Gaza,
It's a point worth
headed
underlining.
into areas
South
where they
Africa
continue
did
to be
not
killed,
give Israel a
and the
reasonable
deliberate creation
opportunity to
of conditions
engage with it
that,
on
quote,
the matters under
lead to a
consideration
slow death,
before
unquote.
filing its no doubt long prepared
There is also
application.
the clear pattern of
One wonders
conduct,
whether South Africa, at the very
the
last moment,
targeting
suddenly
of family
realized
homes
that
and
it needed
civilian
to show the
infrastructure,
existence of a dispute
laying
under the
waste
terms of
to
the
vast
Genocide
areas of
Convention,
Gaza,
and
and the
proceeded
bombing,
to hastily
shelling,
formulate and dispatch
and sniping
a
of
flurry
men,
of notes.
women, and children where they stand, the destruction of the health
The court can
infrastructure,
grant orders for
and lack
provisional
of access
measures
to humanitarian
only where
assistance.
the provisions
So
relied
much so
upon by the applicant
that as we stand today,
appear prima facie to
1%
afford a basis
of the
on which its
Palestinian
jurisdiction
population in
could be
Gaza
founded,
has been
although it need not
systematically
satisfy
decimated.
itself in a definitive
And 1
manner
in 4
that it has
Gazans have
jurisdiction
been injured
as regards the merits
since
of the case.
7 October.
It's
These
not an
two
easy
elements
matter
alone
to determine
are
whether
capable
a prima
of
facie
evidencing
case
Israel's
exists.
genocidal intent
It rests
in
between
relation
full
to the
proof
whole
and
or
complete
part
absence of proof,
of the Palestinian population
and is
in
intended
Gaza.
to ensure that the court functions effectively
However,
and efficiently.
third,
But that has to be
there is an
something
extraordinary
tangible
feature in this
in
case,
terms of the provisions
that
in
Israel's
question.
political leaders, military commanders,
provisional
and
measures
persons holding
procedure
official
is a
positions
complex
have
instrument,
systematically
and
and in
that the court
explicit
has to
terms
decide upon the
declared
basis
their
of certain
genocidal intent.
assumptions which may or may
And
not
these
be
statements
disproved at a later
are then
stage
repeated
of the proceedings.
by soldiers on the ground
This
in
is
Gaza
particularly difficult
as they
in such an
engage in the
egregious
destruction
matter
of Palestinians
as an
and the
allegation
physical
of
infrastructure
genocide.
of Gaza. We show this
Were
third
understood
element
by
next.
the
Israel's special genocidal intent is rooted in the belief that, in fact, the enemy is not just the military wing of Hamas,
Okay.
or indeed Hamas
Well, the
generally,
standard of proof
but is
at
embedded
the merit
in the
stage
fabric
is high.
of Palestinian life
The
in
court
Gaza.
having made it clear that
On 7
claims against
October,
the state
in a
involving
televised
charges
address,
of exceptional
Israeli
gravity
Prime Minister
must be
Benjamin
proved by
Netanyahu
evidence that is
declared war on
fully
Gaza, and I quote,
conclusive.
Israel had
That is not the
started
case, of course, at the
clearing out
provisional measures
the
stage.
communities that have been
It's also not
infiltrated by
negligible.
terrorists. And he
court is
warned
asked
of an unprecedented
to grant in this
price
case
to
a
be
number
paid
of
by the
measures
enemy.
that in effect assume that the party
There are
in
more than
question
2.3
is
million
committing
Palestinians
genocide.
in Gaza.
As Mr. Staker will show
Israel
later this
is the
morning,
occupying power
mud is thrown
in
at a
control of
stage
Gaza.
before conclusive proof.
It controls
and it
entry,
may stick,
exit,
even
and the
if
internal
accusation
movements
is
of inside
comprehensively
Gaza.
disproved at
And
the
qua
merits
Prime Minister,
phase, as we
Mr.
expect.
Netanyahu exercises
A
overall
serious
command
political and
over the
security
Israeli
price
Defense
may be
Force
paid
and in
by
turn
the
the
grantee of such
Palestinians
measures,
in Gaza.
even though it may later be shown
Prime Minister
to be
Netanyahu, in his
completely
address to the
unwarranted.
Israeli forces on
This
28
must
October
surely
2023,
require that the court
preparing for
acts
the
with
invasion of
caution
Gaza,
and
urged the
understanding,
soldiers to
particularly in
remember what
evaluating the
Amalek has
components
done to you.
of the allegation in law.
This refers to the biblical
Provisional
command
measures
by
are
God to
intended to
Saul
constitute
for the
a shield and
retaliatory
not a
destruction
sword,
of an entire
to
group
preserve,
of people
not undermine
known as the
rights.
Amalekites, put
We
to
have shown that
death
one element of
men
Article 9,
and
that
women,
of the need to demonstrate the
children
existence
and
of a
infants,
dispute,
cattle and sheep,
as
camels
understood by the
and
court in
donkeys.
the light of its case law, is
The
lacking.
genocidal invocation
The second
to
element
Amalek
concerns
was
the
anything
question as
but
to whether
idle.
the act complained of
It
by
was
the
repeated
applicant
by Mr.
can be
Netanyahu
seen as
in a
falling
letter to
within
the
the
Israeli
provisions
armed forces on 3
of the convention.
November 2023.
The court has noted
Madam
that only at the
President,
merit
let the
stage
Prime Minister's
can it be
words speak
determined
for
whether
themselves.
the provisions in question of the convention have been violated. To accomplish this,
has done
the
to you,
necessary
says
specific
our Holy
intent to
Bible, and we
destroy
do
in
remember
whole
and
or in
we
part
are
a
fighting
national,
our
racial,
brave troops
or
and
religious
combatants
group
who are
has
now in
such.
Gaza or around
be
Gaza.
proved. However, this cannot be read as a complete rejection of consideration of the intent criteria for current purposes. The court in the Myanmar case noted that a finding of violations at the merit stage notably
The Deputy
depends
Speaker
on the existence
of the
of
Knesset,
intent. Notably,
Israel's
not
parliament,
exclusively.
has called for
Myanmar
the
is
erasure
not a ruling that
of the
intent
Gaza
is
Strip
irrelevant
from the
in a
face
consideration
of
of
the
prima
earth.
facie jurisdiction. It is a ruling
The Defense Force
that the
agrees.
conclusion as to whether or not
On 9
violations
October,
have actually occurred
the Defense Minister,
is a matter for the
Yoav
merits
Gallant,
which notably
gave a
depends
situation
on an
update
assessment
to the
of
army,
intent.
where he
This
said that
clearly
as
leaves
Israel was
open the
imposing a
possibility
complete siege on
that
Gaza,
intent
there would be no
is
electricity,
indeed a
no
factor
food, no
in
water,
determining
no
prima
fuel,
facie jurisdiction
Everything would
in
be closed.
provisional measures
because
proceedings.
Israel is fighting
This also
human
comports
animals.
with the logic of the situation.
Speaking to troops on the Gaza border,
The
he
acts
instructed them
element of the
that he has
definition of
released
genocide
all the restraints
are listed in Article
and that
2,
Gaza
and for
won't
present
return
purposes,
to
there is
what
no
it
need to
was
go through
before.
them. The issue is this.
We will eliminate everything.
What
We will
determines the
reach all
existence
places.
of the crime of genocide
Eliminate
is the intention
everything.
to destroy
Reach
in
all
whole or
places
in part
without any
a particular
restraints.
group as such.
The theme of
That
destruction
is what
of human
distinguishes
animals
genocide
was
from other
reiterated by an
international law
Israeli army
crimes, such as
coordinator
war
of government
crimes or crimes
activities
against
in the
humanity.
territories. On 9
Consider the
October
act- to
2023,
consider the act
who,
alone as
in an
listed
address
in
to
Article
Hamas
2,
and the
with
residents
no
of
reference
Gaza,
at all to
stated
the
that
intent
Hamas has
criterion
become
is thus
ISIS
to
and
denude
that
the
the
crime
citizens
its
of
very
Gaza are
essence.
celebrating
Hamlet
instead
without
of
the
being
praise.
horrified.
A car without
He
an engine.
concluded that human animals are
We are
dealt
at the
with
provisional
accordingly.
measures phase of this case.
Israel has imposed
South
a total
Africa does
blockade
not
on
have to
Gaza.
prove that
No
genocidal
electricity,
acts have
no
been
water,
or
just
are being
damage.
committed.
You
But it
wanted
does
hell,
have to
you will
show
get hell.
that the genocide
The language
convention
of systematic
is in play.
dehumanization is
After all,
evident
this
here.
court has no jurisdiction
Human
to
animals,
consider any
both
other alleged
Hamas
crimes,
and
however
civilians,
serious.
are
We are
condemned.
only concerned with genocide.
Within the Israeli cabinet,
It is indeed a
this is
difficult
also
balance
a
to
widely held view.
The court
The Minister
has
of
stated
Energy and
that what is
Infrastructure,
required
Israel
at
Katz,
this stage is to establish
called
whether
for the
acts
denial of
complained
water
of
and
are
fuel,
capable
as
of
this is
falling
what
within
will
the
happen
provisions
to a
of the
people
Genocide
of children
Convention.
killers
But
and
the acts
slaughterers.
complained of may only
This
be
admits
capable
of no ambiguity.
falling within the
It
provisions
means to
of the
create
Genocide
conditions
Convention.
of death of the
If the
Palestinian
intent
people
is
in
present,
Gaza.
otherwise such acts
To
cannot
die a slow death
constitute
because of
genocide.
starvation and
The
dehydration,
factor of intent
or to die
colours
quickly
the whole
because
question
of a bomb
of
attack
Article
or
2
snipers,
acts.
but to die
In other words,
nevertheless.
That
In
there is
fact,
prima facie evidence
Heritage Minister
that the acts
Amichai Eliyahu
may fall
said
within
that
the
Israel
Convention
must find ways for
necessarily
Gazans
importing
that are more
the
painful
intent
than
elements
death.
have been established.
It is no
as such.
answer to say that
South
neither
Africa
are in command of the
accepts
army.
the need to demonstrate
They
intent.
are ministers in the Israeli
It referred
government
to the concept
They vote
of
in the
specific
Knesset
intent in its application,
and are
both
in a
generally
position to shape
and in the specific
state policy.
context of its discussion
The
of the
intent to
court's
destroy
prima
Gaza
facie
has been
jurisdiction
nurtured at the highest
and
levels of
provisional
state.
measures proceedings.
As President Isaac
Indeed,
Herzog
South Africa
has joined
placed a
the ranks
considerable
of those
emphasis
signing
upon
bombs
intent in its
destined
pleadings
for Gaza.
yesterday by Ms.
Having
Hassin.
previously noted that the entire
Mr.
population in Gaza
Kaitobi
is
devoted his whole
responsible
pleading to
and
this
that this
requirement.
rhetoric about civilians not aware, not
As far as
involved
the
is
acts
absolutely not
are
true.
concerned in this case,
We will fight
there is
until we
little
break their
beyond
backbone.
random assertions to demonstrate that Israel has or has had the specific intent to destroy, in whole or in part, the Palestinian people as such. The intention faced with the 7th of October atrocities and the continuing rocket fire and incarceration of the hostages on the part of Israel to act in order to defend itself so as to terminate the threats against it and rescue the hostages certainly exists. The intent to deal with the armed militants of Hamas and other such groups is undeniable. Were it the case, which we deny, that Israeli forces have transgressed some of the rules of conflict, then the matter will be tackled at the appropriate time by Israel's robust and independent legal system. But that is not the intent to destroy all or part of a people as such. Israel's actions in restricting its targeting practices to attack military personnel or objectives in accordance with international humanitarian law in a proportionate manner in each case, as well as its practice of mitigating civilian harm, such as by forewarning civilians of impending action by the unprecedented and extensive use of telephone calls, leafleting, and so forth, coupled with the facilitation of humanitarian assistance, all demonstrate the precise opposite of any possible genocidal intent. South Africa, in seeking to discover the necessary intent, presents a distorted picture. It misunderstands the nature and provenance of certain comments made by some Israeli politicians. Let me try and explain the big picture. Israel possesses a clear and effective structure of authority with regard to governmental decision. The war against Hamas is managed on behalf of the government by two central organs: the Ministerial Committee on National Security Affairs and the War, and the War Cabinet, the latter established for the purpose of managing the war by the former. These bodies make the relevant decisions regarding the war's conduct, and according to Israeli law, the decisions of the government and its committees obligate the ministers of the government in accordance with the principle of collective responsibility. It is the collective decisions of these bodies which are the binding provisions in question. The Prime Minister stands at the head of these organs, decides on the agenda of their meetings, steers their activity, and summarises the meetings and the instructions issued therein. To make it clear, in order to determine the policy and intentions of the government of Israel, it is necessary to examine the decisions of the Ministerial Committee on National Security Affairs and the War Cabinet, and to examine whether the particular comments expressed conform or not with the policies and decisions made. Thus, to produce random quotes that are not in conformity with government policy, produced as describing, is misleading at best. Such as the statement by the Minister of Heritage, for example, who is completely outside the policy and decision-making process in the war. In any event, his statement was immediately repudiated by members of the War Cabinet and other ministers, including the Prime Minister. In tab 1A of the volume which Israel has submitted to the court, one may find numerous excerpts from internal cabinet decisions that attest to Israel's true intent throughout this war. For example, one finds the instructions from the Prime Minister in a meeting of the Ministerial Committee on National Security Affairs from the 29th of October, stating the following. 1. The Prime Minister stated time and again, we must prevent a humanitarian disaster. 2. The Prime Minister indicated the possible sorts of solutions that will ensure required supply of water, food and medicine, increasing the amount of trucks entering with the necessary inspections. 3. Promoting the construction of field hospitals in the south of the Gaza Strip. To re-emphasise, this is a directive to authorities, nothing less. Tab 1A contains a considerable number of similar directives, emphasising the need to avoid harm to civilians and facilitate humanitarian aid. Genocidal intent? Let me turn to the IDF. This, like every army, is a hierarchical body that operates by way of orders from superiors and is headed by the Chief of the General Staff. Remarks or actions of a soldier do not and cannot reflect policy. In tab 1B, one may find a daily operational directive, which I understand is repeated day by day, issued by the Operations Directorate of the IDF, stating that attacks will be solely directed towards military targets while adhering to the principles of distinction, proportionality, and the obligation taking precautions in attacks in order to reduce collateral damage. This is a directive that binds all IDF forces. It continues by stating that the laws of armed conflict allow destruction to civilian property only when there is a military necessity to do so, and prohibit harm to property for deterrence purposes only, or for the purpose of punishment, individual or collective. It emphasises that it is necessary to treat enemy civilians with respect. They should not be treated in a humiliating manner, and civilians should not be used for the purpose of performing activities that might put them under risk to their life or their body. This is a mandatory instruction, effective since the start of the war. Tab 1B contains many similar provisions, which are themselves only an illustration of many other such directives, orders and procedures. Further, on the 28th of October, the Prime Minister publicly declared that the IDF is doing everything possible to avoid harming those not involved, while on the 18th of November, he declared that, first of all and above all else, Israel acts according to the laws of war. This is how our army works. The Minister of Defence publicly stated on the 29th of October that we are not fighting the Palestinian multitude and the Palestinian people in Gaza, and declared on the 13th of November that our war is against the Hamas terrorist organisation, not the people of Gaza. Again, the President of Israel declared on the 12th of October that we are working, operating militarily according to rules of international law, period, unequivocally. We have collated numerous such statements by the President, by the Prime Minister, by the Minister of Defence, by the IDF spokesperson and others in tab 2 of our volume. Since this is such a critical part of South Africa's thesis, permit me to refer to 2 further statements by the Prime Minister. I start with the most recent, 10th of January. Israel has no intention of permanently occupying Gaza or displacing its civilian population. Israel is fighting Hamas terrorists, not the Palestinian population, and we are doing so in full compliance with international law. The IDF is doing its utmost to minimize civilian casualties, while Hamas is doing its utmost to maximize them by using Palestinian civilians as human shields. The IDF urges Palestinian civilians to leave war zones by disseminating leaflets, making phone calls, providing safe passage corridors, while Hamas prevents Palestinians from leaving at gunpoint and often with gunfire. Our goal is to rid Gaza of Hamas terrorists and free our hostages. Once this is achieved, Gaza can be demilitarized and de-radicalized, thereby creating a possibility for a better future for Israel and Palestinians alike. On 23rd of November, Prime Minister Netanyahu declared that any civilian death is a tragedy, anyone, and to avoid them, what you do is first you try and get the civilian out of harm's way, and that's exactly what we did. There are many more of the same. Any careful review of the official and binding policy decisions made by the relevant authorities in Israel since the outbreak of the war clearly evidence that such decisions lack any genocidal intent. The contrary is true. They are indicative of the consistent and relentless commitment of Israeli relevant authorities to mitigate civilian harm and alleviate civilian suffering in Gaza. Some of the comments to which South Africa refers are clearly rhetorical, made in the immediate aftermath of an event which severely traumatized Israel, but which cannot be seen as demanding genocide. They express anguish and the necessity to restore control over Israel's own territory under severe threat and safety to its citizens. As Judge Tomka has noted, sometimes statements are made which are nothing more than a part of the recent wartime rhetoric, intending to put the blame and shame on the other side. Not to be totally ignored, but not to be ascribed an importance which belies how and when they were made, nor of legal significance. Let me refer to one further matter of some biblical moment. Yesterday, the applicant referred time and again to 2 statements by the Israeli Prime Minister where he said, "Remember what Amalek did to you," and attached great importance to it as part of the argument that Israel has demonstrated a genocidal intent. There is no need here for a theological discussion on the meaning of Amalek in Judaism, which was indeed not understood by the applicant. Let me just turn to the Prime Minister's statement of the 28th of October, which was partially and misleadingly quoted yesterday. He said, "We are now entering the second phase of the war, which its objectives are clear: destruction of the military and governmental capabilities of Hamas and the return of the hostages back home. In the last couple of days, I have met with our soldiers in the bases, in the field, in the north and in the south. Remember what Amalek has done to you. We remember and we are fighting. In front of our brave and hero soldiers, there is one prior mission: to defeat the murderous enemy and secure our existence in our land. The IDF is the most moral army in the world. The IDF does everything to avoid harming the uninvolved." Tab 3 lists and addresses additional examples of misleading quotes by the applicant regarding Israel's policy. It is thus our conclusion that South Africa has failed to demonstrate the prima facie jurisdiction of the court. I turn to the next issue. As the court has noted, its power to grant provisional measures has its object the preservation of the respective rights claimed by the parties in a case pending its decision on the merits. At the provisional measures stage, the court does not need to determine that such rights do actually exist in a definitive manner, but it must establish that such rights are plausible. South Africa yesterday dealt with this rather lightly. We can safely say that plausibility is an elusive concept. Simply declaring the claim rights are plausible is insufficient. The issue was addressed by Judge Greenwood in the border area case when he emphasised that what is required is something more than assertion but less than proof. In other words, the party must show that there is at least a reasonable possibility that the right it claims exists as a matter of law and will be adjudged to apply to that party's case. He later discussed this in terms of a reasonable prospect of success. What is clear is that the court has sought to tie plausibility to particular treaty provisions or to general rules of international law. The court has also considered claims of fact in this context as well as law, such as the finding as to whether Equatorial Guinea plausibly used the building at 42 Avenue Foch for diplomatic purposes. In this case, the court did not limit itself to considering whether the applicant plausibly held the rights in question under international law, but extended the field of inquiry to include consideration as to whether it was plausible that the respondent had breached the rights in question. This approach appears also in Ukraine and Russia, where the court concluded that, on the basis of the evidence presented by the parties, it appears that some of the acts complained of by Ukraine fulfill this condition of plausibility. In other words, the court was prepared to consider not only the question of the plausibility of rights, well, some has shuffled my papers. Well, but also the question of the possible breach of such rights. The power of the court to indicate provisional measures under Article 41 of the statute has its object Yes, someone thought that my speech was a pack of cards. Indeed, in the Jadav case, my apologies, the court was prepared to examine evidence as to the existence of asserted rights and whether, as a matter of fact, the violations had plausibly happened. The final point to be made in this section of my pleading is simply to underline the obvious point that the court needs to consider the relevant respective rights of both parties, the respondent as well as the applicant. Article 41 provides that the purpose of the provisional measures is to preserve the rights of either party. I would note the court order of the 16th of March 2022 in Ukraine, Russia, stating that the power of the court to indicate provisional measures has as its object the preservation of the respective rights claimed by the parties. And further quote the comment in the Myanmar case that the function of provisional measures is to protect the respective rights of either party pending its final decision. This mutual protection or balancing criterion in the light of the rights of both parties, is intended to prevent either party being placed in a situation of disadvantage and to ensure that irreparable prejudice will not be caused to either party. I will look briefly at the relevant rights of both parties here. As regards the applicant, I make three simple and brief points. First, South Africa has presented a confusing and a partial recital of the facts. This will be discussed later this morning by Ms. Rajwan. Secondly, that the appropriate legal framework for this tragic situation is that of international humanitarian law. Thirdly, that Israel's efforts both to mitigate harm when conducting operations, as well as its efforts to alleviate suffering through humanitarian activities, have gone relatively unnoticed and dispel, or at the very least mitigate, against any allegation of genocidal intent. As from Israel's withdrawal of its civilian and military presence from Gaza in 2005, which brought an end to its belligerent occupation, and the violent coming to power of Hamas in 2007, a situation of conflict has existed, with Hamas firing rockets at Israeli towns and villages unceasingly. However, the attack on Israel on the 7th of October was qualitatively different from all that went before. The truth is that if there has been any genocidal activity in this situation, it was the events of 7th of October. Acts and intent can and have been adequately demonstrated. But Hamas, recognised as a terrorist group by at least 41 states, including the US, the UK, all members of the EU, Canada, Australia, Saudi Arabia, Japan and Colombia, is not before the court. Only South Africa, a third party that is not involved in the armed conflict, appears. Nevertheless, as South Africa has pointed out, complicity in genocide is in play. States that supported, condoned, praised or glorified the events of the 7th of October, both at the time and later, stand guilty of a violation of Article 3E of the Convention as being complicit in genocide, and indeed of the duty to prevent genocide under Article 1. And as the agent has pointed out, South Africa has given succour and support to Hamas, at the least. Clearly of relevance to a discussion of the situation is the facilitation of humanitarian assistance, something that hardly sits well with accusations of genocidal intent. As my colleagues will demonstrate, Israel's activities in this area need to be addressed and not swept aside, as South Africa seeks to do. Prime amongst the rights of the respondent that are critical to any legal evaluation of the situation is the inherent right of any state to defend itself, embedded in customary international law and enshrined in the UN Charter. This right, afforded to states, reaffirms and underlines the responsibility of all states towards their citizens and marks the acceptance by the international community of the political reality and legal confirmation that states, when attacked, may legitimately respond in a forceful and proportionate manner. Professor Lowe yesterday sought to maintain that Israel has no right to self-defense in this situation. How could anyone possibly argue that Israel could not defend itself faced with the 7th of October atrocities and the incessant attacks against its civilians since? Indeed, a very wide range of states has acknowledged the right of self-defense here, ranging from the UK to the US, France, Germany, Italy, Canada, Japan, Ghana and Guatemala, and others. Israel bears the responsibility to exercise its protection over its citizens, not only those constantly subjected to bombardment from Gaza, but also and critically with regard to those captured and held hostage as a result of the 7th of October outrage. These rights exist and cannot be disregarded. Of course, Israel does not have any right to violate the law, still less to commit genocide, and indeed it does not, but it does have every right to act to defend itself in accordance with the rules and principles of international law, and so it has done. A link has to be established between the rights asserted and the provisional measures requested, and this issue will be addressed by Mr. Staker. And he will show that the measures proposed go far beyond the protection of the rights asserted. Madam President, members of the Court, this is an important case. Allegations have been made which verge on the outrageous. The attack by Hamas on 7th of October, with its deliberate commission of atrocities, clearly falls within the statutory definition of genocide. Israel's response was and remains legitimate and necessary. It acted and continues to act in a manner consistent with international law. It does so not in an unrestrained manner, but in investing unprecedented efforts in mitigating civilian harm at a cost to its operations, as well as alleviating hardship and suffering with investment of resources and efforts. There is no genocidal intent here. This is no genocide. South Africa tells us only half the story. Israel is guilty of genocide. We cannot deal with Hamas. Only Israel must be stopped from protecting its citizenry and eliminating the egregious threat that is Hamas. We cannot deal with Hamas. Meanwhile, we must bind the arms of the State of Israel. Hamas is for some other body. I conclude. First, the core of genocide is intent. Without intent, there can be no genocide in law. It is true for the merits. It is equally true for provisional measures. Any prima facie consideration, indeed, of intent, even at this preliminary stage, will only demonstrate its absence from Israel's activities. Second, there is here no dispute under the Genocide Convention as at the time of submission of the application, as alleged by South Africa and as required for prima facie jurisdiction. Indeed, South Africa's own precipitate activities with notes over recent weeks demonstrates the lack of its confidence in this respect, and that is telling. Thirdly, the rights to be protected in the provisional measures procedure cover not just the applicant, but also the respondent, and chief amongst these rights is that of the right and obligation to act to defend itself and its citizens. This must be considered and weighed by the court as against the false accusations levelled at Israel. Madam President, members of the court, thank you for your kind attention. I would ask you to call Madame Rajuan at your convenience.
Thank you, Professor Shah. Before I give the floor to the next speaker, the court will observe a coffee break of 10 minutes. The sitting is adjourned. Please be seated.
The sitting is resumed, and I now give the floor to Ms. Galit Ragwan. You have the floor.
Madam President, members of the court, it is an honor to appear before you on behalf of the State of Israel. As Professor Shah noted, at this stage, South Africa does not need to prove that genocidal acts have been or are being committed. But it does have to show that the Genocide Convention is actually relevant. It has to show some level of acts and some level of intent. Professor Shah has spoken to the issue of express intent. It is my task to speak to the circumstances of Israel's actions. Israel cannot possibly comprehensively address today all of the allegations made in South Africa's application in this regard. The applicant paints a dire picture, but it is a partial and deeply flawed picture. The application is so distorted in its descriptions that it prevents the court from properly assessing the plausibility of the rights asserted by South Africa. Plausibility cannot be determined based on the unsubstantiated allegations of one party to the proceedings alone, if Article 41 of the court statute is to have any meaning. In the time available, I will address three aspects of reality on the ground that the applicant has either ignored or misrepresented. First, Hamas's military tactics and strategy. Second, Israel's efforts to mitigate civilian harm during operational activity. And third, Israel's efforts to address humanitarian hardship in Gaza, despite Hamas's attempts at obstruction. With respect to Hamas's military tactics and strategy, it is astounding that in yesterday's hearing, Hamas was mentioned only in passing and only in reference to the October 7 massacre in Israel. Listening to the presentation by the applicant, it was as if Israel is operating in Gaza against no armed adversary, but the same Hamas that carried out the October 7 attacks in Israel is the governing authority in Gaza. And the same Hamas has built a military strategy founded on embedding its assets and operatives in and amongst the civilian population. Urban warfare will always result in tragic deaths, harm, and damage. But in Gaza, these undesired outcomes are exacerbated because they are the desired outcomes of Hamas. In urban warfare, civilian casualties may be the unintended but lawful result of attacks on lawfully military objectives. International humanitarian law recognizes this reality and provides a framework for balancing military necessity with humanitarian considerations. These do not constitute genocidal acts. In the current conflict, many civilian deaths are directly caused by Hamas. Booby-trapped homes detonate and kill indiscriminately. Mines in alleyways collapse structures around them. And over 2,000 rockets, misfired by Hamas, have landed inside Gaza, causing untold levels of harm. One telling example is a blast at the Al-Hali hospital on October 17. Hamas claimed that the Israel Defense Forces, the IDF, attacked the hospital. Headlines around the world rushed to repeat this claim. The IDF later proved, and U.S. intelligence and other national security intelligence agencies independently confirmed that the blast was the result of a failed launch from within Gaza. It was not, as Hamas claimed, the fault of the IDF. Damage to civilian structures is another fact claimed by South Africa as evidence of genocide. But South Africa does not consider the sheer extent to which Hamas uses ostensibly civilian structures for military purposes. Houses, schools, mosques, UN facilities, and shelters are all abused for military purposes by Hamas, including as rocket launching sites. Hundreds of kilometers of tunnels dug by Hamas under populated areas in Gaza often cause structures above to collapse. In the slides before you, you can see a militant priming projectiles for launch on IDF forces in Gaza. You can see the holes in the residential house to hide and launch them. Here, you can see projectiles discovered underneath a bed in a child's bedroom. Here, a rocket being fired from a school. The launch site is circled in red. Here you can see firing from a UN school. You can see the letters UN on the roof, and the fire is circled in red. And here, long-range rocket launchers hidden inside a Scouts Club building. Finally, you can see part of a tunnel that runs for 4 kilometers, including nearby the Erez crossing, which is adjacent to Israel. Gaza's infrastructure has certainly been harmed during the conflict. However, South Africa would have the court believe that Israel is deliberately and unlawfully destroying homes without cause, but harm caused to lawful military objectives and harm caused as a result of Hamas's actions is not evidence of genocide. South Africa also alleges that Israel has waged an assault on Gaza's health system. What South Africa has neglected to bring before the court, however, is the overwhelming evidence of Hamas's military use of such hospitals. Hamas militants retreated to Rantisi Hospital in Gaza on October 7th with hostages from Israel, whom they then held in the basement. In the slide before you, you will see a militant going into Quds Hospital with an RPG. Hamas fired at IDF forces from near and from within the Quds Hospital. At Shifa Hospital, Gaza's largest, Hamas managed operations from a closed-off area. Here you can see an opening to the tunnel that ran for hundreds of meters directly under the hospital. Here, you can see the weapons found in different wings of the hospital. And here, CCTV footage showing armed militants bringing hostages into the hospital's lobby. More than 80 militants hiding inside another hospital, the Adwan Hospital, surrendered themselves to the IDF. And here, you can see a weapon that IDF forces discovered hidden inside incubators at the hospital. The director of the hospital has admitted that numerous members of hospital staff belong to Hamas's military wing. In the Indonesian hospital in the neighborhood of Jabalia, Hamas forces managed their operations from that hospital until the IDF reached it. IDF forces recovered the bodies of 5 murdered hostages from a tunnel dug underneath the hospital. The list goes on. In every single hospital that the IDF has searched in Gaza, it has found evidence of Hamas military use. Israel is acutely aware that because of Hamas's use of hospitals as shields for its military operations, in grave violations of international humanitarian law, patients and staff are at risk. This is why the IDF has reached out to every hospital and offered assistance in relocating patients and staff to safer areas. Hospitals have not been bombed. Rather, the IDF sends soldiers to search and dismantle military infrastructure, reducing damage and disruption. Indeed, the tunnel that sat directly under the main building in Shifa Hospital was exploded without damaging the building above. The IDF then withdrew from the hospital. Yes, damage and harm have occurred as a result of hostilities in hospitals' vicinity, sometimes by IDF fire, sometimes by Hamas, but always as a direct result of Hamas's abhorrent method of warfare. Israel has published plenty of evidence of the extensive misuse by Hamas of medical facilities in direct violations of international humanitarian law. It has brought journalists to see firsthand. It has recorded calls with hospital staffs to coordinate assistance. None of that is mentioned in the application. In fact, the applicant describes the result and asks the court to attribute malicious intent to Israel. But that is only a possible conclusion if one obscures, as the applicant has, Hamas's strategy of turning hospitals into terrorist compounds. The applicant also made much of the fact that force has been even used in humanitarian zones. What the applicant neglected to inform the court, however, was that Hamas has, in its contempt for Palestinian civil life, regularly and deliberately fired from such zones, turning areas of relief into zones of conflict. Here before you, you can see one example of a launch site adjacent to the humanitarian zone, both amplified in larger pictures. And in the next slide, you can see evidence of a rocket launched from next to Gaza's water desalination facility. I now would like to address briefly the second issue, Israel's efforts at mitigation of civilian harm. Here, too, the applicant tells not just a partial story, but a false one. For example, the application presents Israel's call to civilians to evacuate areas of intensive hostilities, quote, as an act calculated to bring about its physical destruction, quote. This is a particularly egregious allegation that is completely disconnected from the governing legal framework of international humanitarian law. Evacuation of civilians is recognized under international humanitarian law as one of the measures that may be implemented to protect civilians from the effects of ongoing hostilities. Indeed, such evacuation may even amount to a duty that the party to the conflict has towards civilians. While temporary evacuation undoubtedly involves hardship and suffering, it is preferable to remaining in areas of intensive hostilities, all the more so when one party makes a concerted effort to use those civilians as shields. The IDF maintains a civilian harm mitigation unit to undertake this task. It works full-time to provide advance notice of areas in which the IDF intends to intensify its activities, coordinate travel routes for civilians, and secure these routes. This unit has developed a detailed map so that specific areas can be temporarily evacuated instead of evacuating entire areas. On the slide before you, you can see that map divided into areas, as well as a screenshot of a video explaining the system in Arabic so civilians may understand it. The IDF also enacts localized pauses in its operations to allow civilians to move. It does this even though Hamas does not agree to do the same, and has even attacked IDF forces securing humanitarian corridors.
Excuse me, I have a request from the interpreters that you slow down the pace of your speaking. Could you please do that? Thank you. Of course. Yesterday, South Africa stated that the IDF gave 24 hours notice to civilians in northern Gaza to evacuate. In fact, the IDF urged civilians to evacuate to southern Gaza for over 3 weeks before it started its ground operation. 3 weeks that provided Hamas with advance knowledge of where and when the IDF would be operating. This 3-week period for temporary evacuation is a matter of common knowledge, and the applicant's misrepresentation of this fact is at best an unfamiliarity with the events, and at worst, a desire to tailor its story to a pre-existing narrative. The IDF employs a range of additional measures in accordance with the obligation to take precautionary measures under international humanitarian law. For example, it provides effective advance warnings of attacks where circumstances permit. To date, the IDF has dropped
millions of leaflets over areas of expected attacks with instructions to evacuate and how to do so, broadcast countless messages over radio and through social media, warning civilians to distance themselves from Hamas operations, and made over 70,000 individual phone calls, including to occupants of the targets, warning them of impending attacks. This requires time, it requires resources and intelligence, and the IDF invests all of these to save civilian lives. Here you can see the IDF's Arabic Twitter account providing information for civilians to evacuate specific areas, including the location of shelters nearby. Yet the applicant astonishingly claims that these efforts are in themselves genocidal. In other words, a measure intended to mitigate harm to the civilian population, sometimes exceeding the requirements of international humanitarian law, is proof, according to the applicant, of Israel's intent to commit genocide, when in fact it proves the exact opposite. My third topic, with respect to the humanitarian situation. Much attention was given by South Africa to this situation. Despite Israel's efforts to mitigate harm, there is no question that many civilians in Gaza are suffering as a result of the war that Hamas began. While Israel is seeking to minimize civilian harm, Hamas is doing everything in its power to use the civilian population and civilian infrastructure for its own protection, thwarting humanitarian efforts aimed at alleviating the distress of the civilian population. Further illustration on Hamas's tactics and Israel's efforts can be found in tabs 4 and 9 of the volume provided to the court. I now turn to describe just some of the humanitarian coordination efforts that Israel has been engaged in, and Mr. Sender will further expand on this. Israel maintains a dedicated military unit called Kogat, responsible for routine coordination with international organizations in Gaza with respect to various humanitarian aspects. It is Kogat that mans and operates the crossings between Israel and Gaza. This includes the Erez crossing, through which prior to October 7, almost 20,000 Gazans passed through into Israel daily for work. South Africa showed a map yesterday, with the Erez crossing marked closed. What it failed to note is that the crossing was attacked on October 7th by Hamas, which murdered and kidnapped Kogat staff and caused significant damage. Here you can see some of that damage. Nevertheless, Kogat works around the clock to fulfill its role. Its large professional staff run numerous initiatives, of which I will only mention a few. First, Kogat manages a mechanism by which it maintains an up-to-date picture of the needs in Gaza. It does this with the UN, other international organizations, and states, whose representatives sit in Kogat's offices. Kogat uses this monitoring to help donor states and organizations prioritize their aid efforts to fit the evolving situation on the ground. Second, Kogat facilitates the entry of aid into Gaza. Israel has publicly stated repeatedly that there is no limit on the amount of food, water, shelter, or medical supplies that can be brought into Gaza. To increase capacity, Kogat has reopened the Kerem Shalom crossing, as acknowledged by the Security Council in Resolution 2720, despite Hamas putting it under fire. Israel has offered to extend operating hours at the crossing if there is a capacity to receive the goods by international organizations on the Gazan side. Third, COGAT works to reinforce and strengthen medical services. COGAT has facilitated the huge logistical challenge of establishing 4 field hospitals in Gaza, and more are being set up, and 2 floating hospitals. It has facilitated the entry of new ambulances into Gaza, and Israel has even coordinated airdrops of aid over Gaza by Jordan, coordinating these flights with the Israel Air Force operating in Gaza. This, of course, is not to say that nothing more can be done, or that there are no challenges to the humanitarian situation in Gaza. Such challenges exist and change according to the evolving circumstances of the conflict. But it is to say that the charge of genocide in the face of these extensive efforts is frankly untenable. It is an inconvenient truth for the applicant's case, but one of the most significant challenges is the fact that Hamas commandeers consignments into Gaza and controls their distribution. Gazan residents have reported that Hamas is regularly stealing aid at the expense of its own population for the benefit of its fighters. This is a tweet stating that fuel and medical equipment was stolen by purported Hamas members from an UNRWA warehouse. UNRWA later deleted the tweet, perhaps under pressure from the authorities. Here you can see Hamas commandeering an aid truck. And here is another example. Because Hamas for years has used aid consignments to smuggle weapons, security checks of all goods going into Gaza are required, as acknowledged by international humanitarian law. Hamas has time and again hoarded fuel, including during the current conflict, which it uses for military purposes to sustain ventilation in its expansive underground tunnel network and for its continued attacks against Israel. Nevertheless, in coordination with the UN, Israel enables fuel to enter Gaza to service essential infrastructure such as sewage treatment, desalination plants, water pumps and hospitals, and cellular infrastructure for maintaining communication. Israel remains committed to helping international organizations and states involved in the aid effort to overcome these hurdles and consistently increase the amount of aid and services available to the population in Gaza, as will be further described by Mr. Sender. Here, a picture of incubators that the IDF provided to Shifa Hospital. Here, a picture of an ambulance convoy coordinated by COGAT. A picture of consignments. A picture of ambulances, the entry of which was coordinated by COGAT. And finally, more consignments waiting to enter Gaza. Madam President, members of the court, in the time allotted, I have been able to describe only some of Israel's efforts to mitigate civilian harm and to address the humanitarian situation in Gaza. But even this mere fraction is enough to demonstrate how tendentious and partial the applicant's presentation of these facts is, and certainly enough to conclude that the allegation of intent to commit genocide is baseless. If Israel had such intent, would it delay a ground maneuver for weeks, urging civilians to seek safer space, and in doing so, sacrificing operational advantage? Would it invest massive resources to provide civilians details about where to go, when to go, how to go, to leave areas of fighting? Would it maintain a dedicated unit staffed with experts whose sole role is to facilitate aid and who continue to do so despite having their staff killed and kidnapped? When a population is ruled by a terrorist organization that cares more about wiping out its neighbor
than about protecting its own civilians, there are acute challenges in protecting the civilian population. Those challenges are exacerbated by the dynamic and evolving nature of intense hostilities in an urban area, where the enemy exploits hospitals, shelters, and critical infrastructure. Would Israel work continuously with international organizations and states, even reaching out to them on its own initiative, to find solutions to these challenges if it were seeking to destroy the population? Israel's efforts to mitigate the ravages of this war on civilians are the very opposite of intent to destroy them. Under these circumstances, far from being the only inference that could reasonably be drawn from Israel's pattern of conduct, intent to commit genocide is not even a plausible inference. Madam President, members of the court, that concludes my statement. I thank you for your kind attention, and I ask that you now invite Mr. Sender to the podium.
I thank Ms. Radwan, and I invite Mr. Omri Sender to address the court. You have the floor.
Thank you. Madam President, members of the court, it is an honor to appear before you today on behalf of the State of Israel. It falls to me to address the condition of risk of irreparable harm and urgency. This third condition is, of course, dependent on the two preceding ones. Professor Shaw and Ms. Radwan have already shown that the provisions relied upon by the applicant do not afford, even prima facie, a basis on which this court's jurisdiction could be founded. They also showed that the rights asserted by the applicant cannot be regarded as plausible. It follows that the irreparable consequences cannot, in the present case, be caused by the alleged disregard of rights under the Genocide Convention. Again, this is not at all to say that the humanitarian situation arising from the present armed conflict is not grave. Civilians have been severely affected by the hostilities instigated by Hamas. Its systematic strategy of prosecuting war from under and within the civilian population exposes civilians to great risk, and it has brought about great suffering. Israel has done and is doing a great deal to alleviate this suffering in very challenging circumstances. In this regard, the factual account provided by the applicant is once again entirely one-sided. The application and request run no less than 84 pages, but they make hardly any mention of the extraordinary efforts undertaken by Israel and by a host of other states and international actors to improve the humanitarian situation. We again heard virtually nothing from the applicant on this issue yesterday. But this is a critical factor in the request before you. As Ms. Radwan has shown, it frustrates any attempt to establish the necessary special intent for genocide. It also bears upon the third condition established in your case law. Madam President, members of the court, we know from your case law that the power of the court to indicate provisional measures will be exercised only in exceptional circumstances. There needs to be, as you have said, a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the court gives its final decision. Your order in the Myanmar case, in which the Genocide Convention was also invoked, suggests that the adoption, and I quote, of concrete measures aimed specifically in recognizing and ensuring the right, end of quote, of the group in question to exist would mean that irreparable harm and urgency cannot be established. Precisely such concrete measures have been taken by Israel. which has been facilitating the provision of more and more humanitarian assistance for people in need throughout the Gaza Strip. These steps have not only been increasing so as to meet the developing situation on the ground. They are continuously undertaken specifically in order to prevent harm to the civilian population. These efforts have had an impact. Just last week, for example, with the assistance of the World Food Programme, a dozen bakeries reopened with the capacity to produce more than 2 million breads a day. The World Food Programme has said the delivery of flour, salt, sugar and yeast continues so as to enable more bakeries to reopen, increasing accessibility and affordability for thousands of families. And since the applicant mentioned yesterday the number of trucks entering Gaza each day before and after the war, the accurate average number for trucks specifically carrying food is 70 trucks a day before the war and 109 trucks a day over the last 2 weeks. All this information may be found in your judge's folder. Access to water has also been a priority. As with food supplies, there is no restriction on the amount of water that may enter Gaza. Israel continues to supply its own water to Gaza by 2 pipelines. It facilitates the delivery of bottled water in large quantities, and it repairs and indeed expands water infrastructure that has been damaged by the fighting. An additional water pipe bringing water into southern Gaza from Egypt began operating a few weeks ago. Access to medical supplies and services is also growing. Israel has so far facilitated the establishment of 4 field hospitals and 2 floating hospitals. The establishment of 2 more hospitals is underway. Israel is facilitating the entry of medical teams into Gaza, as also vaccinations, including in cooperation with UNICEF. Ill and wounded persons are being evacuated through the Rafah border crossing to Egypt, the United Arab Emirates, Turkey, Qatar, and Jordan. Tents and winter equipment are being distributed as well. The constant delivery of fuel and cooking gas is also facilitated. According to official data, again in your judges' folders, from 8 December, the amount of fuel entering Gaza has doubled and currently stands at 180,000 liters a day. This is a target amount requested by the UN itself. Since 21 December, the amount of cooking gas entering Gaza has also doubled, now standing at an average of 90 tons per day. Details of this kind concerning the various ongoing humanitarian efforts are updated every single day on a designated English website of COGAT, the unit in the Ministry of Defense in charge of monitoring the humanitarian situation. When pressing needs are identified, solutions are soon coordinated. A great effort is indeed invested in eliminating bottlenecks so as to improve the entrance and distribution of aid, notwithstanding Hamas constantly stealing it. As you have heard, a joint operations room involving Israel, Egypt, the United States, and the UN operates daily to solve in real time logistical difficulties. Israel also coordinates with various UN agencies and the ICRC to address their own needs. On 15 December, Israel decided to open its crossing at Kerem Shalom with the express intention to improve and upgrade the delivery of humanitarian assistance to Palestinian civilians in Gaza. That part of the government's decision is in your judge's folder as well. This has eased congestion at the Rafah crossing and helped facilitate the provision of greater amounts of aid. Israel facilitates air routes as well for parachuting aid directly into Gaza. Facilitating a maritime corridor is currently being considered with other states. Madam President, members of the court, again, these are just some examples. But they show that Israel, no doubt, meets the legal test of concrete measures aimed specifically at recognizing and ensuring the rights of the Palestinian civilians in Gaza to exist. It has been the daily work of numerous Israeli officials of various agencies to ensure that these and other steps are effectively carried out at a time when they and their families are themselves under constant attack. A determination that the multilateral, large-scale humanitarian effort is lacking, or that scaling up access of humanitarian relief to Gaza would be of no avail, as the applicant would have you believe, should not be made lightly. Madam President, members of the court, two additional elements warrant your careful attention. They too suggest that the condition of urgency is not as easily met as the applicant would have you believe. First, the scope and intensity of the hostilities has been decreasing. Israel's defense minister said last week that Israeli forces would be shifting from the intense maneuvering phase of the war toward, and I quote, different types of special operations. This statement, made in an interview to international media, is found at tab 16A of the volume submitted. This week, on 8 January, the spokesperson for the Israeli military confirmed that the Israeli campaign had already started a transition to fewer ground troops and fewer airstrikes. The war shifted a stage, he said. As you will see in tab 16B of the volume, he spoke of a new and less intense phase of fighting. He specifically mentioned that Israel will continue to reduce the number of troops in Gaza. 5 brigades, consisting of thousands of soldiers, have already been withdrawn from the territory. Second, the UN Security Council has only recently adopted a resolution for the specific purpose of alleviating the humanitarian situation. By Resolution 2720 of 22 December, which is found at tab 16C of the volume, the Council demanded the immediate and unconditional release of all hostages, as well as the delivery of humanitarian assistance at scale directly to the Palestinian civilian population throughout the Gaza Strip. More specifically still, the Council requested the Secretary General to appoint a senior coordinator in order to establish a UN mechanism for accelerating the provision of humanitarian relief consignments to Gaza. Contrary to what we heard yesterday, this resolution does not, and I quote, remain unimplemented. Close quote. A senior coordinator has been appointed and indeed began her work. The Council remains actively seized of the matter. Israel, for its part, is already working with the senior coordinator, and it has just this week coordinated the entrance of a UN delegation into northern Gaza in order to evaluate the situation and map the needs for a future return of Palestinian civilians. I recall in this connection that in the Aegean Sea case, the court found that it was not necessary to indicate provisional measures where the government in question showed willingness to act in accordance with the recommendations of the Security Council concerning the matter before the court. All these recent developments indicate that the facts as they presently exist do not call for awarding interim relief. They also suggest that the difference between the present case and earlier cases that have come before you are very clear. Finally, the lack of urgency within the meaning of the court's case law is further demonstrated by assurances provided before you today by Israel's co-agents. They could not be clearer in stating that Israel remains bound at all times by its international legal obligations. Needless to say, this includes Israel's obligations as a state party to the Genocide Convention. The applicant will have this court say that it cannot take the word of a state. That would be not only unfortunate, it would also be contrary to the law on unilateral declarations of states. Unsurprisingly, your consistent case law suggests that assurances of the kind offered by Israel may well render the indication of provisional measures unnecessary. Madam President, members of the court, the conclusion is that the condition of irreparable prejudice and urgency cannot be met. It is Israel and its citizens who would risk irreparable harm if the request of South Africa were to be granted. Madam President, distinguished members of the court, that concludes my statement. I thank you for your kind attention, and I ask that you now invite Mr. Staker to the podium.
I thank Mr. Sender, and I now invite Mr. Christopher Staker to take the floor. You have the floor, sir.
Madam President, Mr. Vice President, members of the court, it's an honor to appear before you again and to represent the State of Israel. You've now been addressed on why the conditions for provisional measures are not met. That being so, there's no need to examine the 9 particular measures that South Africa requests. Nonetheless, for completeness, I will address each in turn and show that their terms are unwarranted in any event. They go beyond what is necessary to protect rights on an interim basis and therefore also have no link with the rights sought to be protected. I start with the first and second requested measures. These would require immediate suspension of Israel's military operations in Gaza. This request is frankly astonishing. A request is made by a state not party to an ongoing conflict for provisional measures requiring unilateral suspension of military operations by one party to the conflict only, leaving the other party free to continue attacks which it has a stated intention to do. South Africa cannot argue that similar measures were granted in the Russia genocide case. That case was fundamentally different. In the Russia case, the legality of the military operation itself was in issue by reference to the Genocide Convention. Russia had claimed that its military operation was to prevent and punish genocide being committed in Ukraine. The court found it doubtful that the Genocide Convention authorizes a unilateral use of force in the territory of another state, and plausible that Ukraine had a right not to be subjected to military operations by Russia for that purpose. The result, provisional measures could protect a plausible right not to be subjected to military operations. In this case, Israel does not rely on the Genocide Convention or Prevention of Genocide to justify its operations. The lawfulness of the operations themselves does not involve any interpretation, application, or fulfillment of the Convention over which the court has jurisdiction. As jurisdiction in this case is based solely on Article 9 of the Convention, the court cannot find that South Africa or Palestinians in Gaza have a plausible right of the kind in the Russia case. Article 41 of the statute empowers only such provisional measures as the circumstances require to preserve the respective rights of either party. In the Russia case, a suspension of military operations might have been necessary to preserve a right not to be subjected to military operations. But in this case, the right in issue is South Africa's claimed right to ensure observance of the Genocide Convention. It's absurd to suggest that the only way to ensure observance of the Genocide Convention in a military operation is to prevent the operation from being conducted at all, in order, according to South Africa, to secure the humanitarian response and avoid yet more unnecessary death and destruction. That goes beyond preventing genocide. South Africa appears to argue that the military operations as such are genocidal. But how has South Africa established a plausible claim that this is so? Mr. Hassim argued only that it's plausible, quote, that at least some, if not all, of these alleged acts fall within the Convention's provisions. How does at least some acts turn into the military operations as such? The pictures shown yesterday of various individual incidents, whatever they may or may not say about those incidents, are not evidence of the intent of the military operations as a whole. Professor Shaw has addressed you on why the statements of holders of official positions relied on by South Africa do not establish a plausible claim of genocidal intent. The inevitable fatalities and human suffering of any conflict is not of itself a pattern of conduct that plausibly shows genocidal intent. These provisional measures are therefore not within the court's power under Article 41 of the statute. They go well beyond anything required to preserve the specific rights in issue, namely the observance of the Convention in military operations. They seek instead to shut down the military operations themselves. The requested measures seek to reverse the Bosnia case. When provisional measures were ordered in that case, the armed conflict was still in progress. The allegations in that case were similar to those made in this case. Bosnia and Herzegovina specifically requested a provisional measure requiring Yugoslavia to cease and desist from any and all types of military or paramilitary activities against the people, state, and government of Bosnia and Herzegovina. But the court did not grant it, even though, unlike in this case, an ongoing genocide was said to be in progress on the territory of the very state seeking provisional measures, and both parties to the conflict were parties to the case. The court said expressly that it refused because such a measure would be for the protection of a right that could not form the basis of a judgment in exercise of jurisdiction under the Genocide Convention. There is no reason to depart from that case law. In any event, provisional measures cannot be indicated if, as in this case, they would cause irreparable prejudice to the respondent or are out of proportion with the protection that they're intended to give to the applicant. The fact is that provisional measures impose burdens on the party to which they are addressed in order to protect potentially non-existent rights of another party. It would be contrary to the sovereign equality of states for such burdens to be imposed without regard to their effects on the state to which they are addressed. As Judge Abraham said in the pulp mills case, in a request for provisional measures, the court is faced with conflicting rights claimed by the respective parties and cannot avoid weighing those rights against each other. In the Financing of Terrorism Convention case, Judge Tomka said that the court, when considering requests for provisional measures, is expected to weigh and balance the respective rights of the parties. He went on to note, citing specific examples, that this requirement has been observed in the court's practice. The court has made clear in other provisional measures orders that it must preserve the respective rights of both parties. Its established jurisprudence is that Article 41 of the statute, quote, has as its object the preservation of the respective rights claimed by the parties, unquote. That is to say, both parties. The respective rights to be preserved are thus not only the plausible but yet to be determined rights claimed by the applicant, but also the plausible and yet to be determined rights of the respondent to engage in conduct that provisional measures would restrain. Other international dispute settlement fora also balance the interests of both parties when ordering provisional measures. Already a century ago, a mixed arbitral tribunal recognized a principle that the possible injury to the addressee of provisional measures must not be out of proportion with the advantage which the claimant hopes to derive from them. The Institute of International Law has now recognized a general principle of law that international and national courts and tribunals may grant interim relief, and, as a requirement for such measures, that the risk of injury to the applicant must outweigh the risk of injury to the respondent. This principle is also recognized by other international dispute settlement mechanisms. Other principles applied when indicating provisional measures are that none of the parties can be put at a disadvantage, that measures should not go beyond what is necessary to achieve their end, that the measures must not cause irreparable prejudice to the rights of the respondent, and that any impression of bias must be avoided. These principles are all aspects of the most basic and elementary duty of the court to ensure equality between the parties. Article 41 of the statute states that provisional measures are to preserve the respective rights of either party. It does not refer solely to the rights of the applicant for provisional measures. Not to apply such principles would be absurd. Suppose that the Genocide Convention and the court had already been in existence during the Second World War, and that the Allied powers were all parties to the convention without reservation, while the Axis powers were not. Suppose that a neutral state had brought proceedings against the Allied powers, alleging breaches of the Genocide Convention and their conduct of hostilities, and requesting provisional measures requiring the Allies to cease hostilities immediately, invoking pictures of civilian fatalities and suffering in the war as a plausible claim. Such provisional measures would have required the Allies to surrender to the Axis powers, even though the case against them might later have been held to be wholly unfounded, without any consideration by the court of whether genocide was being committed by the Axis powers. Provisional measures must have their limits. Could a provisional measure require a state to change its government, or to vote in a particular way in the General Assembly? The answer must be no. Can provisional measures require a state to refrain from exercising a plausible right to defend itself? The answer must be the same. In this case, the balancing of interests must take into account the following. First, Hamas is considered to be a terrorist organization by Israel and other states. Second, it's undisputed that on 7 October, Hamas committed on Israeli territory a large-scale terrorist attack. This is continuing. Third, Israel's right to conduct the military operations in exercise of its right to defend itself has been recognized internationally. Fourth, Israel is committed to complying with international humanitarian law. And fifth, Israel is taking steps to alleviate the humanitarian situation. The co-agents and other counsel have and will address you on this. Sixth, this is not a case where provisional measures could require both parties to a conflict to exercise mutual restraint. They would not be binding on Hamas. Seventh, Hamas has made clear its intention to carry out continuing attacks against Israel and its citizens. Eighth, provisional measures would deprive Israel of the ability to contend with this security threat against it. More rockets could be fired into its territory, more of its citizens could be taken hostage, raped and tortured, and further atrocities could be conducted from across the Gazan border, but provisional measures would prevent Israel from doing anything. Ninth, provisional measures would end attempts to rescue those already taken hostage. 10th, suspension of military operations would give Hamas space to preserve and build its capabilities, enabling it to pose an even greater threat and to use remaining hostages as bargaining chips. If granted, the result would be this: an organization recognized internationally as terrorist has committed a terrorist atrocity in the territory of a state. And a third state now seeks an order from this court that would prevent the attacked state from responding, but which would impose no obligation on those responsible for the attack. The requested measures would not put an end to the conflict, but only to military operations by one party to the conflict. These measures would assist the other party and encourage the commission of further terrorist attacks. In this respect also, the Russia case is fundamentally distinguishable from this case. Provisional measures should be a temporary shield to preserve claimed but as yet unproven rights pending a decision on the merits. Instead, they're being used here as a sword to give an advantage to one party in a conflict over another. The irreparable prejudice to Israel is obvious. So is the lack of proportionality. Madam President, members of the court, Israel's position is that there is no conceivable basis on which the first two provisional measures could be ordered. I turn then to the third requested measure. This would require Israel to take all reasonable measures to prevent genocide. This is analogous to the first provisional measure in both the Bosnia case and the Myanmar case. There are two further objections to this measure. First, its wording is not confined to the current military operations in Gaza. It's expressed to apply in relation to the Palestinian people generally. This opens the possibility to later claims that actions by Israel having nothing to do with Gaza are in breach of this provisional measure. While the Convention obligation to prevent genocide may not be confined to current operations in Gaza, the subject matter of this case is. There is no justification for the provisional measure to extend beyond the claim itself. This particular objection applies also to the fourth and seventh requested measure. A second objection is that this third provisional measure would impose the same obligation on South Africa as well. No reason is given for this. The other requested provisional measures do not apply to South Africa. Why this one? Is South Africa saying it may fail to comply with its obligation to prevent genocide if not compelled to do so by a provisional measure? Unlikely. Rather, through this provisional measure, South Africa appears to seek a special mandate from the court to act internationally in relation to Palestinian issues on the basis that it seeks to prevent genocide. Indeed, if South Africa's right to bring these proceedings was disputed, South Africa might argue that this provisional measure gives it the right. However, provisional measures cannot confer special mandates on states and no justification for doing so is established in any event. The third provisional measure should therefore not be granted. I move on to the fourth requested measure. This would require Israel to desist from committing acts within the scope of Article 2 of the Convention. There are fundamental objections to this measure. First, it has no counterpart in the provisional measures ordered in the Bosnia and Myanmar cases. What's the need for this special novel measure? No explanation is given. Second, it uses the word desist, which implies that violations of the Convention by Israel are occurring. It seeks an implied ruling on the merits. In the Bosnia case, you declined to grant a provisional measure requested by Bosnia and Herzegovina that Yugoslavia must cease and desist from all acts of genocide. You should also refuse this request. It's one thing to call on a state to comply with its obligations under the Convention. It's quite another to imply that a state has failed to do so. While provisional measures are without prejudice to the merits, such an implied finding will tarnish the reputation of the respondent state, which is not only unprincipled, but also unnecessary within the meaning of Article 41 of the statute to protect claimed rights on an interim basis. Third, this measure refers to acts within the scope of Article 2 of the Convention. Now, although an act is not within the scope of Article 2 unless it's committed with genocidal intent, the proposed wording leaves scope for South Africa subsequently to argue that the words mean only the acts themselves, whether committed with genocidal intent or not. On that interpretation, the effect would be to shut down Israel's military operation. Every killing or wounding of an opposing combatant by Israeli forces, every collateral civilian casualty, no matter how lawful under international humanitarian law, would be a breach of this provisional measure. Even security checks by Israeli forces of humanitarian aid entering Gaza, in accordance with international humanitarian law as recognized by Security Council Resolution 2720, might be argued to be a breach. The request for this measure should be rejected for the same reasons as the first and second measures. I next address the fifth requested measure. This specifies types of acts to be regarded as deliberately inflicting conditions of life calculated to bring about physical destruction for purposes of the fourth provisional measure. This measure is also objectionable. First, it's not a freestanding measure, but an elaboration of paragraph C of the fourth measure. If the fourth measure is not granted, then the fifth measure falls away. Secondly, no analogous provision is found in the provisional measures order in the Bosnia and Myanmar cases, and no special need for such a new measure is established. Third, it again uses the word desist. Fourth, it seeks further impermissible implied rulings on the merits. For instance, it refers to so-called expulsion and forced displacement of Palestinians from their homes. This is an apparent reference to Israel's practice of issuing calls for civilians to temporarily evacuate areas of intense hostilities, which is in fact a measure to mitigate harm to civilians. This measure thus seeks the court's ruling that evacuation calls amount to expulsion and forced displacement of Palestinians from their homes. Does South Africa suggest that Israel should cease giving warnings to civilians before military operations? How would that protect the rights that South Africa claims? Similarly, paragraph C of this measure seeks the court's ruling that damage to buildings in military operations, presumably even when lawful under international humanitarian law, amount to the destruction of Palestinian life in Gaza. Overall, paragraphs A to C of this measure, read together with paragraph C of the third measure, seek the court's ruling on the merits that evacuation calls, the current humanitarian situation and damage to buildings all amount to deliberately inflicting on the group conditions of life within the meaning of Article 2C of the Convention. The reality is that the conflict and the humanitarian situation cannot be resolved overnight. This provisional measure seems designed to ensure that Israel will be in breach of it as soon as it is made. Its sole purpose seems to be to prejudice the merits, not to preserve rights on an interim basis. it should also not be granted. The sixth requested measure incorporates two separate measures. The first of these would require Israel to ensure that its military and organizations and persons subject to its control do not commit acts falling within Articles 2 or 3 of the Convention. It's analogous to the second provisional measure in the Bosnia and Myanmar cases, respectively. But an objection to this is the reference to any irregular armed units or individuals that may be directed, supported, or otherwise influenced by Israel. This wording has simply been copied from the second provisional measure in the Bosnia and Myanmar cases. However, in those cases, the applications instituting proceedings expressly allege the existence of irregular armed units. The reference is inappropriate in this case. There's no suggestion of forces other than the Israel Defense Forces on whose commitment to international humanitarian law you have and will be addressed on today. The second part of the sixth provisional measure contains an obligation to punish genocide. No such provision was included in the Bosnia or Myanmar provisional measures order. Punishment of genocide is not something that needs to be done urgently in order to protect claim rights on a provisional basis. This measure should also not be granted. The seventh provisional measure also comprises two separate measures. The first would require Israel to take measures to prevent destruction of evidence. The court has indicated such a measure on two recent occasions, but declined to do so on two other recent occasions, despite a specific request by the applicant. In the cases where it was granted, the application for provisional measures specifically alleged that evidence was being destroyed or concealed. In this case, South Africa makes just a bare assertion that there are serious concerns about the destruction of evidence and its effect on future investigation into crimes, and a hampering of scrutiny of Israel's actions. South Africa appears to suggest that the effects of the military operations themselves amount to destruction of evidence, making this yet a further provisional measure, effectively seeking a suspension of military operations. The granting of this measure would imply that there is some reason to suspect concealment of evidence when in fact none has been identified. This again would be an unprincipled and unnecessary tarnishing of reputation. The second part of this measure would require Israel not to impede access to Gaza by fact-finding missions, international mandates, and other bodies. However, it is noted first that access to Gaza from Egypt is under the control of Egypt. Secondly, Israel has no obligation under international law to allow access from its territory into Gaza. Thirdly, a provisional measure to this effect was requested by the applicant in the Myanmar case, and it was not granted by the court. The need for this measure has not been established. The eighth requested measure would require Israel to submit regular reports to the court on measures taken to give effect to the provisional measures. Provisions for such reports were made in two recent provisional measures orders, but on four other occasions it was refused despite being specifically requested by the applicant. This shows that such measures are not routinely granted. They've been granted occasionally when specific action has been indicated. In Armenia versus Azerbaijan, the court said that a report was necessary in view of the specific provisional measures it's decided to indicate and in light of the undertakings made by the agent of Azerbaijan. South Africa does not justify the inclusion of such a measure. There is no shortage of publicly available Israeli material and reports about the present situation in Gaza. Finally, the ninth requested measure is a non-aggravation measure. On two recent occasions, such a measure was specifically requested by the applicant but not granted by the court. Again, such a measure is not the norm, and again, South Africa does not justify its necessity. Provisional measures for non-aggravation have been indicated in cases where both parties have been directly involved as actors in the facts of the case, and the provisional measures have always applied equally to both parties. Thus, in Myanmar, the court declined to grant such a measure. An obligation of non-aggravation cannot fairly be imposed on only one party to a case or only one party to a conflict. If the proposed measure was granted, South Africa would remain free to aggravate its claim dispute with Israel, and Hamas would not be impeded from escalating the conflict with Israel. The only purpose of this provisional measure appears to be to prevent Israel from responding to any such escalations. Again, there's no justification for this measure. Madam President, members of the Court, that concludes my arguments on the inappropriateness of the specific measures requested by South Africa. I thank you for your careful attention. I invite you to call on Mr. Noam, co-agent of Israel, to conclude Israel's arguments.
I thank Mr. Staker, and I now invite the co-agent of Israel, Mr. Gilad Noam, to address the Court. You have the floor, sir.
Madam President, members of the Court, Council have shown that the applicant has failed to make the case for the indication of provisional measures. More specifically, 1. The Court lacks prima facie jurisdiction, as the applicant has not shown any dispute between itself and the respondent at the time the application was submitted. Indeed, it tried to mislead the Court into believing that one had existed. 2. The applicant has failed to meet the condition of plausible rights to be protected in the present circumstances. 3. The simple reality is that the events which are the subject of these proceedings are occurring in the framework of a war instigated by Hamas, governed by the legal framework of international humanitarian law. They do not fall within the remit of the Genocide Convention. 4. The standard of irreparable harm and urgency is not met either. Israel is constantly taking concrete steps, together with others, to address the humanitarian situation in Gaza. 5. Finally, we have shown that each of the provisional measures sought are unwarranted and prejudicial. All this requires that we give attention to two fundamental matters arising from these proceedings. The first is that the applicant seeks to portray an image of Israel as a lawless state that regards itself as beyond and above the law. The applicant paints an image of Israel as a state in which the entire public service, military, and society have in concert discarded Israel's long-standing commitment to law and morality and become singularly consumed with destroying an entire population. That is patently false. I can attest to that firsthand as the Deputy Attorney General for International Law. In this position, I regularly advise the government on issues of international law, including humanitarian law. This has not changed since October 7th. The conflict with Hamas poses serious operational and legal challenges. In conducting close-quarter urban combat while mitigating harm to the surroundings, in seeking to put a stop to Hamas military use of hospitals while minimizing disruption of medical services, in helping civilians leave areas of the most intense fighting while Hamas forces them to stay in the line of fire, in facilitating the provision of aid when that aid is constantly stolen by Hamas to sustain its military efforts, in balancing humanitarian considerations with the need to act forcefully against an adversary that still fires rockets deep into our country and holds our citizens hostage. As the authority responsible for international law advice to Israel's government and cabinet, I can attest that in contending with these challenges, Israel remains committed to international law. When the cannons roar in Gaza, the law is not silent. This has been the case since Israel's establishment in 1948, the same year the Genocide Convention was adopted. Israel's commitment to the rule of law has remained steadfast throughout our history, despite the complex challenges we face as a nation. It reflects the commitments made at the time the state was established, as reflected in our Declaration of Independence, which makes express reference to the principles of the Charter of the United Nations. In 1948 too, Israel was at war, forced upon it. Yet, despite being engaged in a war for its survival, the young state gave great importance to immediately establishing an effective, independent and impartial legal system. Indeed, one of the first steps the newly formed IDF took in the midst of a war was to establish a military justice system. This system has evolved into an integral part of the institutional structure of the IDF. Thus, the IDF Military Advocate General holds the highest rank in the IDF, save the Chief of Staff, and is institutionally independent from the military chain of command. Her staff, including international law experts, are interwoven into all aspects of the military's activities. They provide legal training and education. They are involved in the drafting and preparation of military plans and doctrines. And they provide ongoing legal advice on a range of issues, including targeting, weaponry, and obligations towards the enemy's civilian population. This remains the case in the current conflict. The civilian legal system, including my department in the Ministry of Justice, serves as an avenue of review for the military legal system. The Attorney General stands at the head of the civilian legal system. In this position, she too enjoys full institutional independence. At all times, the doors to Israel's courts, including Israel's Supreme Court, remain open. This court is widely acknowledged for its willingness to consider issues pertaining to the conduct of hostilities, including ongoing hostilities. Indeed, during the current conflict, the court has already considered petitions on different aspects of the war. Israel's legal system also ensures accountability. The IDF has a robust law enforcement system. It also maintains an independent mechanism for examining and investigating alleged violations of international humanitarian law. This mechanism is subject to review and oversight by the civilian justice system, including the Supreme Court. This system has been structurally strengthened over the past decade, including by consultations with like-minded states and international experts. Assessing incidents in large-scale hostilities outside of a state's territory requires expertise. Our system is provided with substantial resources and authority to fulfill its mission. The military mechanism is already reviewing incidents relating to the current conflict. The rule of law remains a foundational pillar of the State of Israel. The applicant defames not only Israel's leadership, but also Israeli society. Misrepresenting a selective assortment of statements to suggest genocidal intentions and the abdication of core moral values. Israel's counsel, Professor Shaw, addressed this claim. The shock, anxiety, and deep pain that have affected Israeli society since October 7th naturally lead to harsh statements regarding the enemy that is committed to, indeed driven by, destruction of Jews and Israelis. But our legal system knows how to draw a line between statements that may be troubling and even obscene, but fall within the right of freedom of speech in a democratic society, and those statements which go beyond that right. As the Attorney General reaffirmed publicly recently, any statement calling for intentional harm to civilians contradicts the policy of the State of Israel and may amount to a criminal offense, including the offense of incitement. Several such cases are currently being examined by Israeli law enforcement authorities. You will find this statement in tab 16D in the volume. Madam President, members of the Court, a second general matter we alluded to is the broader implications of this application for Israel and the wider international community. As we have shown, this case concerns a large-scale armed conflict with tragic consequences for civilians on both sides. Yes, there is a heart-wrenching armed conflict. But the attempt to classify it as genocide and trigger provisional measures is not just unfounded in law. It has far-reaching and negative implications that extend well beyond the case before you. Ultimately, entertaining the applicant's request will not strengthen the commitment to prevent and punish genocide, but weaken it. It will turn an instrument adopted by the international community to prevent horrors of the kind that shocked the conscience of humanity during the Holocaust into a weapon in the hands of terrorist groups who have no regard for humanity or for the law. If every resort to force in self-defense against an enemy hiding behind civilians can be portrayed as genocide and trigger provisional measures, an inevitable tension will be created between the Genocide Convention and states defending themselves against the ever-increasing capacities of terrorist organizations. Doing so would also signal to terrorist organizations that they can commit war crimes and crimes against humanity and then exploit this court to obtain protection. For us, provisional measures would lead to a perverse situation. It would effectively allow Hamas to continue attacking the citizens of Israel, to hold 136 hostages in unbearable conditions, to keep tens of thousands of displaced Israelis from returning to their homes, and essentially to promote its plan to massacre as many Israelis and Jews as it can. Madam President, members of the court, in living memory of the atrocities that gave birth to the term genocide, in the aftermath of which the State of Israel was founded, we are witness to a concerted and cynical effort to pervert the meaning of the term genocide itself. The Genocide Convention is too important a foundation in humanity's aspiration to defeat barbarism and evil to be belittled in this way. And the faith that has been placed in international law and its institutions is too cherished an asset to be squandered. We appeal to this court not to be taken down that dangerous road. Madam President, members of the court, for all the above reasons, Israel requests the court, in accordance with Article 60, paragraph 2 of the rules of the court, for the reasons given during the hearing of January 12, 2024, and any other reasons the court might deem appropriate. 1, to reject the request for the indication of provisional measures submitted by the applicant. 2, to remove the case from its list. Madam President and members of the court, that concludes Israel's observations. Thank you for your kind attention.
I thank the co-agent of Israel, whose statement brings to an end the single round of oral argument of Israel, as well as the present series of sitting. In accordance with the usual practice, I shall request the agents of both parties to remain at the court's disposal to provide any additional information the court may require. The court will render its order on the request for the indication of provisional measures submitted by South Africa as soon as possible. The agents of the parties will be advised in due course as to the date on which the court will deliver the order in public sitting. Since the court has no other business before it today, the sitting is declared closed.